and it came into effect across the whole Reich same day, 19 September 1941. Its mandatory character could not be in doubt, and it was immediately recognized as an important escalation, conditioning how the burghers mass shootings of Jews from their town. There is much talk in the population about all Germans in America having to wear a swastika on their left breast in order to make them recognizable, along the lines of the way the Jews have been identified here in Germany.
But for sure, it's 2 cases of all of it. The green over here, it's gonna be a lot more. We're gonna, I even told them to lock it. We haven't sold a single one. But we gotta get it to her today. I told her before she can get it for
All right, ladies and gentlemen, I have about 9 o'clock. I'll go ahead and start calling the dockets. I'll call the Frio dockets and then the other civil dockets. I'll ask for announcements from the attorneys. Anyone who's present who either does not have an attorney or their attorney is not present, please let me know that you're here. Apart from that, please keep your electronic device muted. Ms. Riley, I'm going to make you the host so that you can start breakout rooms later. Thank you. All right. In the interest of Noah Salinas, a child.
No, sir.
Helena, Mr. Salinas is here. I don't know if she's here or not.
Yes, she's in the other room, the Frio DC. She's about to answer.
I'm here.
Okay.
We're ready.
Who is on the other side?
Clarissa Silva.
And what do we have to hear today?
Temporary orders.
I'll mark you conferring. 14-9-342 in the interest of ZAS and LMS children.
Present.
Your Honor, I'm present on that. Attorney Berta Gutierrez. Mr. Sauceda, do you have an attorney?
I'm in the process of hiring an attorney.
If you can mark us conferring, Your Honor, on that one, please.
I will.
Thank you.
All right, tax cases, City of Dilley versus Lazaro Carrizales et al.
Judge, we're going to reset that to April 8th, please.
Okay, all the attorneys, if you're resetting things, if there's no dispute about the date it's going to, if you would post that to everyone in chat in the cause number, style, and date format. As soon as you do that on all your cases, as long as you're correct that you've done it, you're released.
Thank you, Judge.
Frio Hospital District et al. Versus Norma Gandara.
Judge, both the plaintiffs and interveners are ready to take a default judgment.
That's correct, Judge.
I will take all the tax cases at once. Matter of the marriage of William O'Connor and Eliza Shapa.
That's for Cnty, correct?
Yes.
2010-296. Matter of the marriage of William O'Connor and Eliza Shapa.
Mrs. Cnty, William Russell is present for Mrs. Cnty, Your Honor.
And I'm here for Mr. O'Connor, Your Honor.
Okay. So is the Shapa incorrect or is Shapa endicon too?
That's
Yes,
correct.
Your Honor, I made a mistake when I filed.
All right. What do we have to hear today?
It's supposed to be for entry of order, and I have a motion for drug testing here today.
Your Honor, we have a motion to rehear that matter and a motion for further temporary orders.
That is not set for today, though.
It was set for today. It was a discussion we had with it previously.
All right, I will mark you conferring in 30 minutes. Ask you to confer in a breakout room. And for all the attorneys, when I say confer in a breakout room, if you can't get it settled, that's fine. But I want you to have discussed things like if you're going to try and introduce bank records, cell phone records, photographs of the kids and the family and things like that. I want you to have looked at all of that ahead of time and either know that it's going to be admitted by agreement or know that it's not going to be admitted by agreement and you have to prove it up. I don't want to have to stop hearings for the attorneys to show each other their exhibits when they were supposed to have been conferring. The matter of the marriage of Pamela and Daniel Nash.
I'm present, Your Honor.
Okay. And you are?
Daniel Nash.
All right, because the electronic device says Pam Nash. And do you know where Pamela Nash is?
I am here, Your Honor.
Two of you ready to go forward?
Yes, Your Honor.
Yes, Your Honor.
Okay, I will mark you A. You'll be the first self-represented case that I call up. I take up the uncontested matters with attorneys before those without attorneys. Okay. Diana Garcia versus Calvin Spear et al.
Morning, Your Honor. Excuse me, Rob Negrin on behalf of myself and Paul Hofker, substitute trustees.
Good morning, Your Honor. Jacob Sparks on behalf of Carrington Mortgage Services.
Okay, and what do we have to hear this morning?
Your Honor, the matter before you is the motion that I filed on behalf of myself as well as my partner, Paul Hofker, who were named in the lawsuit as substitute trustees and only in that capacity. The motion was brought pursuant to the property code, which permits or requires dismissal of us without prejudice upon the occurrence of certain parameters which have occurred, and the parties have submitted an unopposed or an agreed order for the dismissal of us without prejudice, Your Honor.
Okay. All right. So if everyone's in a concurrence with that, if you will just post that to me in chat in a PDF format, I will sign it.
Yes, Your Honor.
We need a hearing. Is that it? All right, Mr. Sparks, everyone's in agreement or not?
Yes, Your Honor. I represent a co-defendant who is being substituted out because Carrington Mortgage Services transferred the loan. So I don't represent the plaintiff. We certainly are not opposed to Mr. Negrin's motion.
And has anyone heard anything from Mr. Maldonado?
I spoke with Mr. Maldonado, Your Honor. It's unopposed. Mr. Maldonado has agreed and signed the order.
Okay, just post that to me in chat. I'll sign it, post it to the clerk.
Yes, Your Honor.
Matter of the marriage of Amanda Vega and Joe Flores.
I'm present, Your Honor.
All right, and is Mr. Flores present?
No, sir, he signed the waiver to not be present.
Okay, I will mark you B. You'll be the second self-represented case I call up.
Thank you, Your Honor.
(21-225) in the interest of GDR, AKB, and MLB children.
Your Honor, good morning. Sylvia Rodriguez on behalf of the applicants or the petitioners, Lois West and Lisa West. Your Honor, we filed a motion to extend the temporary restraining order. And this morning we filed a corrected order extending the temporary restraining order. Unfortunately, we have not been able to accomplish service on the 3 biological parents. So we are asking that the temporary restraining order that was previously issued be extended and that this matters be set for hearing on or about March the 22nd, Judge.
Okay, and have you verified that date with the coordinator's office?
I have my office doing that right now, Judge.
Okay, if you will post your proposed extension order and post that to me in chat in the clause number style date format, I will sign it.
Thank you, Judge. And we'll wait on until that gets done, if that's okay with the court.
Sure.
Okay, thank you, Judge.
All right. Atascosa County, United Built Homes versus Miguel Flores et al.
Judge, I'm here on that with the ad litem, Mr. Patrick Smitherman. I believe that we're fairly in agreement on the motion for summary judgment, but we'll need approximately 20 minutes to prove up our attorney's fees.
And I'll mark you 20 minutes.
Thank you, Judge.
Okay, Frio County, Ditech Financial versus all occupants of 704 Helena Road.
Good morning, Your Honor. This is
County,
attorney.
not Frio, I'm sorry.
Good morning, Your Honor. This is attorney Carlos Hernandez Vivoni on behalf of the plaintiff, Your Honor. We're ready to move forward with this case.
Okay, and is Jeffrey Hill or anyone else on the other side present? Right, and has there been a pro se answer filed, I take it?
Yes, sir.
All right. And have you had any other contact with the defendant?
No, Your Honor.
All right, I'll mark you A, but before I recall the case, I'm going to ask just that you call if you have a number or email and see if you get any sort of response. I've just had several cases like this, especially with Zoom, where the defendant doesn't get in until 9:45 or 10 o'clock, and then we have to get the attorney back. So we'll do that, and I'll check on things.
We'll do so, Your Honor.
Okay. Wilson County, Cassandra Blackman versus Steve Blackman.
Your Honor, Teresa Nettles for Stephen Blackman. We're ready on that. I don't know if Miss Blackman will be appearing, or she hasn't had it.
Unfortunately, I do not have legal representation.
All right.
I also
are
did
you
not know.
announcing-
I'm sorry,
are you
Your
announcing
Honor.
ready? Are you announcing not ready?
I'm not ready due to the fact I do not have legal representation. I did not know about this court date nor the one in February. It was unbeknownst to me. The only way I found out was through an email at very last minute.
Okay, I will mark you conferring, and I will recall this case.
Thank you, Your Honor.
Matter of the marriage of Roy and Dina Messick.
Your Honor, I'm here, Alan Manka, present. I understand Ms. White is in another court.
Yes, Your Honor, I'm here. I'm waiting for the a not ready announcement in Bear County.
I didn't get notice of this till Friday when I got the Zoom information from Ms. Riley. And Judge, I've got a hearing this afternoon in Bandera County, so I need to be excused at 1 o'clock.
Okay, so what's signed today? Or what's on set today?
Mr. Mankas, I believe, request to withdraw temporary orders.
The orders have been withdrawn. I think Ms. White wants another copy signed. And I guess she wants you to go through piece by piece on page by page of the order.
So, to my knowledge, there's not been an order signed setting aside these temporary orders. Mr. Manka has some issues. If you remember, Judge, he was in another court. We waited a couple hours and you signed the temporary orders.
Yes, but I was under a misapprehension as to what sort of notice he had had.
Okay.
It was all one way or another this morning. I will mark you conferring.
Thank you, Judge.
All right, 2 p.m. Be in Ray Douglas Edward Lockbaum. Anyone present right now for that? Okay. Anyone else told to be here today, your case was not called?
Your Honor.
Okay, do I have any other dockets, Ms. Riley, that I should have been calling?
No, sir, not that I have.
Your Honor.
Your Honor.
Okay, let me go from the bottom up. There's an iPhone. This says iPhone. What's your name?
Sorry, this is Kenny Lamb. I'm using a secondary computer, and so I have to use the phone to talk. Your Honor, myself and Stephen Barrera are back from the continuation of the Tuttle hearing yesterday. There was just some information that we wanted to present to the court, and then I believe Mr. Barrera has already drafted some orders for the court.
Okay, all right, so I will get back with, I will call Tuttle in a moment. Who else was told to be here? Your case was not called. All right.
Your Honor, and this is in regards to the Stanteen case. It's the cause number 16-010030 CVW for temporary orders. I represent the petitioner, Ms. Lakendra Hastings, and we've announced for 1 hour.
Okay, I'm going to ask you to get with, who's here from Wilson County?
I am, Judge.
Okay, I'm going to ask you to get with Ms. Kruger in chat, and I will ask her to pull the file. Who is here on the other side?
I believe Miss Erica Thomas is the respondent, and I thought I saw her on here as well.
Yes.
I'm not sure if she's represented though.
I'm here.
Okay, all right. And I'll mark y'all conferring. So Erica Thomas, pro se, are you both ready to proceed?
We are present and ready, Your Honor, and we have a couple witnesses also. And Your Honor, I do have a mediation starting at 1 o'clock today as well.
Okay, all right, so we'll see. So Ms. Thomas, are you ready to proceed?
Yes, sir, I am, Your Honor.
Okay, I'll mark you conferring in 60 minutes.
Thank you, Judge.
And Judge, I do apologize. It looks like that case should have been on the docket today. It looks like the date was entered incorrectly.
Okay, and the cause number is 16 what?
01-00030 CVW. It's in the interest of Edward Veli Stanteen Jr.
Okay, I'll mark y'all conferring. Anyone else?
Thank you, Judge.
Judge.
Okay, I'll let the attorneys who need to confer. If you will get with Ms. Riley. She is the host and she can set up breakout rooms. And Ms. Thomas, I'm going to ask you and Ms. Aldrich to confer also. You should get an invitation, I hope, to a breakout room. It's a little blue box at the bottom that will take you off to an individual room that you can speak at. All right, so let me get this unopposed order signed. And I will start on Tuttle.
Your Honor, just real quick on the West matter or on the cause number 21-225, March 22nd is an acceptable date. So we are posting that corrected order extending the TRO on chat for Your Honor's consideration.
Thank you. I will look at that.
May my clients be excused, Your Honor?
Yes, ma'am.
Okay. Thank you, Judge.
Thank you.
Sure.
Okay, I've just posted the signed order dismissing Ditech Financial, dismissing the trustees. Oh, hey, I'm sorry. No, that I did sign the right one. I had closed it and then there was something else up there and I was supposed to say, man, I didn't need to post that. Okay, so y'all should have that.
The order dismissing, Your Honor, the
Yes.
trustee. Thank you. May I be excused, Your Honor.
Yes, sir.
Have a great day.
Okay, and I see I've gotten something from Frio County. What is that? It says Nash.
That'll be the first case you hear, the A for the final divorce decree.
Oh, okay, thank you.
Yes.
I just sent an invite to Miss Aldrich and Erica Thomas to breakout room 1.
Thank you. Okay, Mr. Lamb, Mr. Ferreira.
Yes, Your Honor.
Okay.
Your Honor, so yesterday, after the hearing, we had a chance to talk with the jail administrator at the Sheriff's Department, and it turns out they do not have the ability to administer oxygen to Mr. Tuttle while he's being housed at the jail. So given that information, we prepared orders on a motion. We prepared orders reducing the bonds back to the original amount. And we put additional bond conditions in place requiring the use of the GPS ankle monitor.
As well as weekly UA testing.
And I sent an email this morning, Judge, with the order granting the reduction and the attached additional conditions.
Well, here they are. Okay. So I was going to say I saw something in my judge's queue, but that was not it.
The only issue that comes up, Your Honor, is I have talked to probation. There is a little bit of an issue in that Brittany Ibarra, who coordinates the GPS ankle monitor, she is out this week. I did talk to Lara Tristan. She said she could help coordinate that, but the vendors have indicated it could be a turnaround anywhere from 3 days to a week before they can get Mr. Tuttle set up with an ankle monitor. So I was gonna see if there was any possibility that he could be released with an agreement that he returned to get the ankle monitor installed, or he has to do it within a week or something like that, just because it's already been about 7 or 8 days that he's been in there without the being able to be cared for like he needs to be.
Mr. Lamb?
And Your Honor, the state would be opposed to we spoken to Mr. Barrera last night on this issue. The state's opposed to that simply because of the nature of the case, and having two separate cases. The state would be opposed and would say that we could try to get probation to expedite it. It is a few days to get the GPS, but outside of that, we can try to get it expedited, and we would request that he have the GPS before he leave the county jail.
And is the sheriff going to take him someplace with a deputy where he can receive oxygen?
From our understanding, that was not the case, Your Honor. They would be able to provide all the medications that he was deemed necessary at the jail. There was some, Mr. Barrera was on that conversation. There was some of the medication was expired. They're providing him the appropriate medications now. The oxygen is one thing that they cannot provide. They cannot provide him.
Yeah, our understanding based on that conversation is the oxygen is a no-go. They just do not have the capabilities of doing that.
And I know that, I don't know that it's technically explosive, but it's an oxidizer in.
Yes, Your Honor.
It will take a spark and turn it into a roaring flame. I used to play with my dad's acetylene and oxygen tanks, much to his annoyance when I was young. Okay, I will release him with an order to have the monitor installed by the next business day. Now, I only received, it looks like 21-247. I only received one. Were there two counts? Is there two cause numbers? I don't remember.
Two cause numbers, Your Honor.
Two cause numbers, Your Honor. If I didn't send the second one, I'll send it now.
Let me look.
There should be, there's
I did only opened one. Okay, I've got them both. Okay, and I'm changing this to say it's reduced back to the previously posted $30,000.
Okay.
So I will sign these, post all of these. Is anyone from Atascosa County online?
I don't believe so, Your Honor. I don't believe. Oh no, Chris is here.
Okay. All right, I will post these in just a moment.
The only additional issue I would have, Judge, is in terms of the timeline of he has to have it installed the next day. My understanding, and this is talking to Lada, is that is subject to the vendor being available. Yes. They use two vendors. One of them is Recovery Monitoring Solutions out of San Antonio. Ms. Tristan was telling me that they have 2 or 3 technicians and they get out to Atascosa County maybe once a week. And then the other is El Paso Bail Bonds does monitoring, but they've been telling people it takes about 3 days to get that set up. So that would be my only concern is that the family's on it. I've already communicated with the family, but I just don't want a situation where the vendor just can't do it and we have a bond revocation as a consequence.
Okay, I'm editing this. And I would ask Mr. Brewer that you make it clear to Mr. Tuttle that there's no nudge, nudge, wink, wink here. I mean, I don't want the sheriff's department to have to be having him, putting him in a hospital all by himself and having to do all that, or have him possibly not getting medical care he needs, but that if he's not going to follow the rules, then he's going to have to be locked up, and then the sheriff's department and you and he are going to have to just see what happens from that. All right.
Yes, Your Honor. I've been talking to Lada to see how we could facilitate this thing in the fastest way possible.
Okay. And I think we decided yesterday that it was 30,000 in each case.
Yes, Your Honor.
Yes, Your Honor.
Okay, and I only see bond conditions, additional bond conditions on one of it. That ought to be plenty. Okay, I just posted both of those.
Thank you, Your Honor.
That's all I have, Judge. May I be excused?
Yes, ma'am. Yeah,
Sure.
yes, sir.
It's okay.
Yes.
My coffee's still kicking in too.
I'm looking at Sylvia Rodriguez because I'm downloading the orders on her case. I think that's where I came from. I don't know. Go ahead. You too, Mr. Lamb. I'll see you. No, I guess I'll see Mark at 2 o'clock.
Thank you, Your Honor. Have a good one.
I just sent a breakout room invite to Jacob Salceda and Bertha Gutierrez, if you'll accept that and go into breakout room 2, please.
Your Honor, this is Tina. I am on the case of Bertha Gutierrez and Jacob Salceda. I can get invited to that breakout room.
Okay. Ms. Riley, Lori Riley is the host. I made her the host, so she's doing breakout rooms.
Thank you.
And Tina, what is your name? Tina what?
It's Tina's iPhone, I believe.
Okay. I'm not sure if she's.
Yes, Tina's iPhone. It's Tina Gonzalez.
Okay, I'm not sure she wants you in there with her, but let me double check.
Okay, thank you.
And Your Honor, this is Sylvia Rodriguez. Did you have any questions regarding my order, Your Honor?
No, and that's just the Exhibit A.
Yes, sir. That is the previous order that had been signed by the court judge. We attached it as an Exhibit A to the order extending the temporary restraining order. Yes, sir.
All right, no, they came through.
Thank you, Judge. May I be excused?
Yes, I'm about to post them back if you'll.
Yes, sir. I'll get that. Then I'll get that. And thank you so very much. You have a wonderful day.
Your Honor, this is Clarissa Silva on the case of Peter Salinas.
Yes, ma'am.
I just wanted to let you know that I need more time to seek an attorney, and there.
Okay,
I don't
and
believe.
ma'am, hold on, just I shouldn't have answered. Let me get this saved.
Tina, your attorney did not want you in the room at this time.
Okay, thank you.
You're welcome.
Okay, I posted the extension on the Frio County case. All right, and who was speaking to me saying they're not ready?
Clarissa Silva. I needed more time to seek an attorney, and I wanted to contest against the restraining order. I feel there's no need for the restraining
Okay,
order.
ma'am, let me find this.
My son is in no
Ma'am,
harm.
ma'am? Okay. Where's Mr. Roberts? Okay.
We're trying to answer the criminal docket too, Judge. It's
Okay.
a confusing mess. But I'm here and I'm ready to confer with her if she wants to
Okay,
confer with me.
Well, she's announcing not ready, but have you all had a chance to confer this morning?
We are ready. She's been served, Your Honor. We
All
want
right.
to go forward and
All right, Ms. Roberts, but have you had a chance to confer this morning?
no, I'd like to confer with her.
All right, all right. Ms. Silva, I'm not even.
If you can give me a breakout room, I'll do it.
All right, Ms. Riley's the host. She's in charge of the breakout rooms. All right, Ms. Silva, I'm not even going to discuss resetting this until you've had a chance to talk to Mr. Roberts. It may be that y'all can get this worked out this morning. If you can, that's great. If you cannot, perhaps you can at least narrow down what you've got a disagreement about. And if you can't do that at all, then I will talk with you. We'll come back and we'll discuss your announcement of not ready.
Okay, thank you.
I think we can work a good bit of it out this morning, Your Honor.
Okay.
I invite y'all to breakout room 3 if you'll accept that, please.
Okay, Ditech Financial versus all the occupants of 704 Helena Road. Were you able to?
Your Honor, we checked the file, saw that the pro se answer of the defendant contains no information whatsoever as to their email or telephone number. So unfortunately, Your Honor, we couldn't reach out to the defendant.
All right, sir. Well, are you ready to proceed?
Yes, Your Honor.
All right, without objection, I'll take judicial notice of the entire content of the district clerk's files. Go ahead, sir.
Your Honor, this case was filed and the defendant was served. He appeared and made his answer. A motion for summary judgment.
How do I join that breakout room?
Excuse me. A motion for summary judgment has been filed, Your Honor, and at this time remains uncontested. All conditions precedent are included in the court registry, with our petition or the motion for summary judgment. At this moment, Your Honor, and because the loan was delinquent, we're seeking summary judgment in order to repossess our collateral, and that's the purpose of our motion for summary judgment, Your Honor. We will end up obtaining writ to recover the collateral. We're moving this court discretion for entry of our summary judgment.
Okay, and I have previously reviewed everything in this case. I think I'd kick the summary judgment back because of the pro se answer. And I will grant the motion for summary judgment. Let me get this signed. I was emailed a proposed order.
Your Honor, excuse
Yes,
me.
sir.
I didn't get that. What was the court ruling? I'm sorry.
I granted your motion.
Thank you, Your Honor.
Emailed a proposed order. Is that the correct order?
Yes, Your Honor.
All right, I have just posted that judgment. The clerk's office should be able to get it.
Thank you, Your Honor. Permission to be excused.
You're excused, yes, sir.
Thank you.
Okay, we ready on the tax cases?
Yes, sir. Yes, Judge, we are.
Yes, Judge.
And did there turn out just to be one, actually? Two.
Just one.
Frio County Hospital District. All right, calling Frio County Hospital District versus Gandara.
Judge, tax authorities are ready to proceed to enter a default judgment.
Go ahead.
We'd like to file, take judicial notice of the court's file of all parties were served.
All right, I will take judicial notice of the entire contents of the court's file, and if it's just one, if you'll hold on, let me go ahead and sign in. All right, go ahead, sir.
Also, we're going to attach, as we would like to enter into evidence, the certified tax statements for both plaintiffs and interveners, prima facie evidence of the delinquent taxes that are currently due against the property owners, and allow us to foreclose those property taxes if the property owners have not set up any type of formal payment contract.
Intervener would join in that, Judge.
Without objection, I'll grant those motions. And give me just a moment. Computer is running slowly. Well, here it comes. I don't see any answers in the citations. And do you have your proposed order or judgment? You're muted, Mr. Rocha.
Judge, we have the judgment prepared and we'll forward that over once we get the certified tax statements attached.
Okay, the return's in proper format. There's no pro se answer. If you will file your proposed judgment, I will sign it.
Thank you, Judge.
Thank you, Judge.
Yes, sir.
Thank you. Have a good day.
Thank you.
Exit from this.
Judge, this is Dahlia from the district clerk in Frio County.
Yes, ma'am.
Okay, we did receive, it looks like that on that 21-2-00025, we received back for Sylvia Rodriguez, but it was the Exhibit A. We haven't received the extended TRO.
All right. Guess I clicked on the wrong one. Let me look here. Okay, it was the corrected extension. There you go.
Thank you, Judge.
Yes, ma'am. All right, give me just a minute. We're going to look at the Nash divorce. I hope. Let's see if I can get the clerk's records to go.
And Judge, we received a call, Norman received a call from a Janae West on that 2102-25 CVF Frio County case, saying she was having issues with her phone getting on the Zoom hearing. I'm not sure she's appeared yet, but just an FYI on that, so Judge.
Okay.
I'm here.
just.
I'm here. This is Janae West.
Okay, how do you spell your name, ma'am?
Janae.
All right, I'm going to ask you to hold on and ask Ms. Riley to see if you can get Sylvia Rodriguez back on the phone.
Yes, sir. We'll call her office right now.
Thank you. Okay, in the matter of the marriage of Nash. Is Pamela Nash here?
Yes, Your Honor.
All right. And Daniel Nash was here a while ago. There he is. Okay, are the two of you ready to proceed?
Yes, Your Honor.
Okay, and do you have your proposed divorce decree?
Yes,
Yes.
And do I have a copy of it?
I believe so, Your Honor. If
Yes,
what-
I sent it earlier, but I can resend it if to be more recent. At 9:16, I sent it
By
by
email
chat.
or in chat. Okay, let me go back to 9:16. Okay. All right, here we go. Excellent. You look at this. Okay, are both sides proceed?
Yes, Your Honor.
Yes, Your Honor.
Give me just a moment to let Ms. Rodriguez get in here. All right, Ms. Rodriguez, Janae West just appeared, and I believe just from the last name that's in the case. I just signed the extension of temporary orders on.
Yes, Your Honor, she is the biological mother, and my clients are maternal grandparents. If the court will be so kind as to ask her for an address, Judge, we don't have an address for service on her.
Okay, and Ms. West, where did you go? There you are. Okay. All right. So are you making an appearance in this case and announcing ready, Ms. West, or?
Well, I mean, I was trying to. I don't know if I can because I haven't been served. I tried to get all the information because I hadn't been served, but I could give my address.
Okay, I'm going to ask Ms. Riley to put Ms. Rodriguez into a breakout room. And you should get a little blue box inviting you off to a separate room. And I'll ask you to go there and get with Ms. Rodriguez, and then you all to report back whether we need to do something today or whether it's going to remain set for the 22nd.
Yes, Your Honor.
How do I do break off if I'm doing it by phone?
All right.
It will give you a message in the middle of your phone.
Okay.
And
Right.
Your Honor, the other two parents are, there's a individual by the name of Lorenzo Reyes, and the second father is Juan Villalobos. Are they on the screen by any chance as well?
Not that I know of, but I see a gentleman who has a Samsung and a beard. What is your name, sir?
You're on mute, sir.
I just muted you again. I'm sorry. Go ahead. Sir, you're muted again.
There we go. How's that?
That's great.
Ubaldo Garcia.
Not my friend.
Okay, and are you here for a case? Are you a witness?
A witness.
All right. Thank you, Mr. Garcia. I will change your name.
Thank you.
Okay. Mr. and Ms. Nash, will you raise your right hands? Each of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, I couldn't hear you, Ms. Nash.
Yes, Your Honor.
Mr. Nash?
Yes, Your Honor.
All right, and you put your hands down. Okay, I believe Pamela Nash was the petitioner. Ms. Nash, prior to the time this lawsuit was filed, had you been a resident of Frio County for 90 days in Texas for 6 months?
Yes, Your Honor.
Again, I'm going to ask you to speak up because I can just.
Okay. I apologize. Yes, Your Honor.
Has the and you're married to Daniel Nash?
Yes, Judge.
And has the marriage between the two of you become undermined due to a discord or conflict of personalities?
No, Your Honor.
Okay. All right. Well, why are you asking for a divorce?
Um,
Let me rephrase that. That's a term of art. There's two different categories of divorce in Texas. One is no fault divorce, meaning that you just can't get along with each other and you want a divorce that way. The other is the other old grounds for divorce, which is abandonment, cruel treatment, insanity, things like that. So are you asking for a divorce just because the two of you are not getting along, or for some other specific at-fault reason?
Just because we can't get along, Your Honor.
Okay. At this time, do you think there's any likelihood that the two of you are going to reconcile and live together as husband and wife?
No, Your Honor.
When did the two of you marry?
August 30th, 2014.
Okay. And since that date, have any children been born to you?
No, Your Honor.
And are you expecting a child?
No, Your Honor.
Have the two of you adopted any children?
No.
Are either of you in bankruptcy?
No, Your Honor.
Now, I need to tell you both that the law in Texas presumes that every single thing a married person owns is community property. The moment you get married, the law has that presumption. And if the divorce decree does not either say that property is community property and this is how you're going to divide it up, or say that there's separate property and it doesn't need to be divided up because it's separate property, then the law presumes that the two of you still own the property together after your divorce, and that the judge just forgot to divide it. So I see that there's basically nothing listed on your divorce decree, but it says see attached document, but there's nothing attached to my copy of the divorce decree.
I'm sorry, Your Honor. We
Please
had
stand on there.
submitted our written agreement with our initial decree when we filed.
All right, Ms. Nash, let me tell you that, I mean, I can't be your attorney. I've looked at that document. I would very much suggest to you that you would be better off writing down in your divorce decree exactly what's going to happen. I see language in your divorce decree that says things along the lines of Daniel has agreed that he doesn't want X. Okay. So what? That doesn't say the judge gives this to Pam and takes away all of Daniel's interest in it, or the other way around. Now, if you want to just attach that, I'll get a copy of it and slap it on the divorce decree, and that's good enough. But I think you should very seriously consider, especially as it looks like there's real estate, that you very carefully consider going in and filling out the divorce decree completely and making sure that it's in the decree so there's no dispute as to who winds up with something, and you don't wind up with either you or your creditors at some time in the future trying to parse language along the lines of, well, he's agreed that he doesn't want something. So would you prefer to do that and come back either later today or at another date, or do you want to just proceed with attachment of what you have written up previously?
I would be comfortable proceeding, Your Honor, if Daniel is.
And do you believe that what you have drawn up in your attachment to your divorce decree, do you believe that that is a fair way to split up your property?
Yes, Your Honor.
And are you asking for a name change?
I was, Your Honor, but Mr. Nash and I had discussed that it would be all right if I kept Nash since I have established my career under the last name Nash.
All right, and ma'am, this is nothing to do with him. So are you asking for a name change or not?
Can we put it on there, Your Honor? And
Okay, ma'am, you can get your name restored to a previous name, or you could not do that, whichever you want.
yes, Your Honor.
Yes, you want it changed, or no, you don't want it changed?
Yes, Your Honor, I would like a name change.
Okay, a name change to what?
Dunbar, D-U-N-B-A-R.
And is there a middle name?
Judith.
Okay, now there's also blanks in the divorce decree for when each of you is supposed to pay your own debts. And do you want any date put in there, or do you want to just stick with whatever language you had in the document you signed and filed with your divorce decree that had language about who was going to pay debts?
Your Honor, we'll just stick with the language in the document.
All right. Okay, Mr. Nash, you heard what was testified to by your wife. Is everything she said true and correct?
Yes, sir.
Do you have any questions for her at this time?
No, Your Honor.
And would you, are you willing to go forward with just what you had assigned prior to the divorce, or would you prefer to fill out the divorce decree completely and come back at a later date?
I'm fine with the previous document. We both talked about it quite a bit and agreed upon it, so I'm fine with what we have.
Give me just a moment.
Your Honor, may I address the court?
Yes, ma'am.
I've conferred with Ms. West. She's given me her address, phone numbers for herself and for phone numbers for the two other fathers. She is aware that we have an order that's going to reset this case to March the 22nd. She's in agreement with that, and hopefully I can get her served either today or tomorrow, Your Honor.
Okay, excellent.
And
So-
if we may be excused, Judge.
Yes, ma'am.
Thank you. God bless you. Have a good day.
All right, give me just a moment. All right, I find I have jurisdiction to hear this matter. Actually, Mr. Nash, do you believe that also this is a fair way to divide your marital property and debts?
Yes, Your Honor.
All right. The petitioner had been a resident of Frio County for 90 days and Texas for 6 months prior to the time this lawsuit was filed. The respondent has executed a waiver of citation in the proper format, and he has also appeared in open court and announced ready and has signed off on the divorce decree. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no likelihood of reconciliation. There were no children born or adopted during the marriage, and none are expected. And I find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. I will restore the petitioner's previous name of Pamela Judith Dunbar, and I will grant any of that relief. I'll pronounce the divorce in open court. Any relief that does not appear in this divorce decree is denied, so this is a final appealable order. All right, we get this signed. Now, there's one more thing that's called a BVS, or Bureau of Vital Statistics sheet. That's just a fill-in-the-blank form that reports this divorce to Austin. Has one of y'all prepared that divorce, that form?
No, Your Honor, I didn't see that form. I apologize.
Okay. All right. I'll just ask you to get with the district clerk's office. They will typically require you to get that form filled out and filed with them before they will give you a copy of your divorce decree.
Yes, sir.
And I have just signed the divorce decree, and now I will post that to the district clerk's office.
Thank you, Judge.
All right, in the matter of the marriage of Vega.
Yes, Your Honor.
All right, let me look at this in the records.
Your Honor?
Yes, sir.
We have, Miss Silva and I have agreed on an agreed order modifying this situation. She's coming to my office to look at it and sign it.
Okay. All right, that's
so
I'm glad y'all got that worked
I just
out.
want to report that. She should be there somewhere. I don't see her on there, but she's coming to my office. There are 3 or 4 things that we have agreed to that I'm going to change in here to satisfy her. And we should be through with that.
Okay, excellent. All right. Now, in the matter of the marriage of Vega, ma'am, do you have your proposed divorce decree?
Yes, sir, I do.
Okay, do I have a copy of it?
Yes, sir, it was turned into the county, to the district clerk yesterday. It was hand delivered, sir.
Okay, was this, let me ask the clerk's office, do I have a copy of it? All right, well, I'll come back. Apparently they've stepped away. So let me go back up here and look. Ms. Gutierrez, Mr. Sauceda, are you still conferring? Yes.
Judge, we have an agreed reset on this case,
Okay,
and that is for April 8th. As well, pending the reset until we come back April 8th, Mr. Sauceda's visitation will be suspended by agreement. And I have forwarded Mr. Sauceda a Rule 11, waiting for him to review it and send it back so we can have the court sign it as well.
Do I just send that back to you?
Yes, sir. So I can forward to the court.
good. All right, we'll see y'all or whoever's the judge on the April 8th. I'm glad you got that worked out.
Thank you, Judge.
Okay.
Are we dismissed from the court?
Yes, sir. Once you've gotten that back to Ms. Gutierrez, yes, sir.
Okay, thank you.
Thank you, Judge.
Okay, you still 30 minutes on the matter of the marriage of O'Connor and Cantu?
Yes, Your Honor.
Okay.
Unless you're going to hear the temporary orders.
I'm not sure what I'm doing. We'll get into that. I just was hoping that got settled too. Okay. And did the clerk's office come back on in Frio County?
We're on here, Judge. We're just having a little difficulty with Dalia's computer sending you the document. So if you'll just give us a couple of minutes here to figure it out.
Okay, go ahead.
Thank you.
Okay, and on Blackman, do we have a time announcement or has that been worked out?
No, Your Honor, I believe that Ms. Blackman was asking for more time from the court. We're asking the court to deny that.
All right. Is there a divorce in this? Is it just a protective order?
Your Honor, the only thing set for today is the protective order. This was there's also a divorce within this matter. She filed for a protective order in Bowie County on March 18th of 2020. There's been no movement on this. This was transferred to Wilson County on April 8th, 2020. There seems to have been no need to pursue this, and we're asking the court to do a partial dismissal just on the protective order.
All right, and this was legal aid case when it began?
Can you repeat that, Your Honor? I'm sorry, I did not hear your last sentence.
This was a legal aid case when it began?
Yes, Your Honor.
And has the case been sent over to TRLA or have they turned it down or?
Yes, it was turned over. They did have to originally turn it down due to COVID. Everyone in their law firm had caught COVID, so they had to close their doors to all clients. Since then, I have tried and I have sent applications to at least 5 different lawyers and all have rejected me. I even went back to the legal aid, the local legal aid here within the San Antonio area to see if they were willing to represent me. And again, they were unable to due to lack of staff members and resources.
I'm trying to reset mine for May 11th. I'm trying to reset mine for May 11th.
All right, was the motion, Ms. Wong's motion to withdraw ever ruled on?
Your Honor, Ms. Wong told me that there was a signed order, I believe, on 1/28 of this year.
All right, I'm not one, but all right, and Ms. Nettles, what's the necessity, if this case is not final, to get the protective order dismissed?
Your Honor, because of the issues with the case, there's supervised visitation against Ms. Blackman. We would like to finalize the divorce. The divorce has been pending this entire time, so we're asking that this portion of the application of protective order be denied in order for this to move forward on the divorce.
So is the divorce in the same cause number, or is it different cause number?
It's in the same cause number, Your Honor.
Right, well, I see a 222 cause number. Were they combined together?
Yes, Your Honor. They put it into, let me double check. I believe that they had originally put it into the same cause number in the order. Let me double check that. I believe that the 2256 was the cause number it was transferred into.
Yes.
I mean, 256. The divorce was originally filed here in Wilson County. You ordered a writ of attachment for us to be able to get the child from Texarkana, and we were able to bring them back, and there's temporary orders in place for supervised visitation.
All right, I'll grant the motion to dismiss the
Thank you.
protective order. That's without prejudice, but just for, okay. All right, do you have an order on that?
Your Honor, I can send that over to the clerk shortly.
All right.
Thank you, Your Honor.
Do we need a date? Does it have a date for final hearing or just reset on request?
We can get a date for final hearing 45 days out, Your Honor, while Ms. Blackman's still here.
All right, why don't you do that?
Yes, Your Honor.
Is April 22nd good? Is that close to the 45 days of the 29th?
The 29th will work for us.
Okay. And that's on the Blackman case?
Yes.
Ma'am, would you mind repeating that date, please, for confirmation?
April 29th?
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Yes, as soon as you post that to me in chat and the cause number, post it to everyone in chat in the cause number, style, date format. Yes, ma'am.
Thank you, Your Honor.
Okay, in the Vega case, I have something from Ophelia. All right. That's to the Vega divorce decree.
Yes, Judge, and this is Dahlia. I'm back on, so I resent it again from my computer just to make sure.
All right, thank you. All right. Ms. Vega, would you raise your right hand?
Yes, sir.
You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. All right. Now, I asked you before where Mr. Flores was, and your response was that he had filed a waiver of citation.
Yes, sir.
Okay. Where is his signature on the divorce decree?
So I was told that he didn't have to sign it right now, that we could sign it afterwards. And he actually just said, I don't care to sign it. That was his response to me.
Okay. All right. There's two different waivers of citation he can sign. Okay. One says, Judge, just do whatever you want to do. Don't bother me about this anymore. The other says, Judge, the only thing I'm giving up is the right to have the sheriff hunt me down and hand me a copy of the citation and the petition for divorce. And I want to have notice of all hearings, and I don't want you to sign any papers unless I've signed off on them. Your husband signed the second type. So I have to either have his signature on the divorce decree, or I have to have him in here in court, or you have to have given him notice under the rules of civil procedure, formally telling him when the court date was, so that I know that the reason he's not here is because he doesn't want to be here.
So I did give him notice.
Okay. How did you give him notice?
I did let him know via text message.
Okay.
And he responded, and I have the response that he gave me, that he doesn't care to know anything about it. Just do what you need to do.
Give me a moment.
Judge, this is Lori. I'm leaving, and I'm going to make Norma the host, and
all right, thank you.
I'll be back. I'm not sure what time, but I should be back.
All right, ma'am, you need not to just give him a text message. If you're trying to give them formal notice, you need to get a setting. Did you get a copy of, did you get a setting notice or confirmation from the clerk's, pardon me, from the coordinator's office when you set this for hearing?
So I got that actually yesterday. They emailed me that. Your Honor, if I may, as I was reviewing the waiver, I do see that the second part says where he signed it to say, I give up my right to be notified at any and all hearings. I agree that the judge or associate judge in the county and state may make decisions about my divorce, even though the divorce has been. So I believe that he.
All right, ma'am. I'm looking at the waiver of citation that's file stamped December 4th, 2020. And it
So
doesn't
this-
say that.
So this is the one that I submitted to the court. Is this the copy you have?
Hold on. Okay, show me the front page of that.
So this is the front page.
No, that's not the one I have. That's not the one that was filed with the court.
Yes, and I do have it under e-file. Then this is the one that was notarized and signed by him. And this was the waiver that I.
All right, ma'am. I'm not going to debate this with you. What I'll tell you is that's not what was filed at 4 p.m. on December 4th, 2020 with the district clerk's office in Frio County. The one that was.
Sir, I didn't file a
Ma'am,
divorce.
I'm not going to argue this with you, okay? There is a waiver of citation on file in this case from your husband that is a specific waiver where he is specifically waiving only service of citation. If you wish to have the divorce to go forward, you need him in the Zoom hearing, you need his signature on the divorce decree, or you need to send him notice, certified mail or email with a copy of the document from the coordinator's office setting this matter for trial at some date in the future. And then you
Your
need
Honor.
and show that, okay?
Your Honor, may I make a statement quickly? I didn't file, you're giving me a date of December 4th, but I didn't file this petition until January 13th. So I'm not sure if you actually have the correct paperwork, Your Honor, because my divorce, all of the paperwork that I have was not filed until January 13th of 2021. So I'm not sure where December 4th is coming into play, sir. Nothing was started until January 13th.
All right, let me disconnect and check back in. You're Amanda Vega.
Correct, sir.
Joe Mark Flores.
Correct, sir. I apologize. That is my school bell. I'm going to mute it so that you don't hear that.
Okay. I don't know what happened, but I click on it and now I've got two documents open that both say they're the waiver. And one of them is the specific and one's not. I guess it pulled that up from another case and it's so little I can't read it. I can just see it's specific waiver. Okay, I apologize to you, ma'am. You did it correctly.
You're okay, Your Honor. Thank you.
Well, I'm looking right at it, but I only got a little tiny picture, but that's on me. I should have been more
That's okay, Your Honor.
certain that that's what I was seeing from the correct case. I don't know why it pulled it up from a different case.
That's okay, Your Honor.
Prior to the time this lawsuit was filed, have you been a resident of Frio County for 90 days in Texas for 6 months?
Yes, Your Honor.
Okay. You're married to Joe Mark Flores.
Yes, Your Honor.
All right. When did you marry him?
Our actual date of marriage was August 7th of 2020. However, we had been together for approximately 10 years.
Okay. Since the date of your marriage, there have been any children born to you?
Not since the date of the official marriage, Your Honor.
Okay. Are you expecting a child at this time?
No, Your Honor.
Yeah. You have two children who were born prior to the marriage, Jalissa and Jorian?
Yes, Your Honor.
Okay. And there is a order in cause number 14258 in Frio County for child support.
Correct, Your Honor.
When was the last order in that case put in?
The last modified order, I believe, was done in May of 2018, if I'm not mistaken, and we actually have a modified, coming up soon. It's already been submitted. But it's standard visitation, standard.
All right, give me a minute to go and pull that up. Let me ask the clerk's office, is it likely that all of the documents are in?
Yes, everything should be in the case.
On the 2014 case?
Yes, I did not check that one, the 14.8. 14.258.
Yes. Well,
Okay.
yeah, yes, 14.258.
Okay, yeah, I haven't checked that one. Let me see what we have on that one, just a moment.
All right. And ma'am, did you have a child who passed away?
Yes, sir, we did.
Okay.
Yes, the last stuff on there is 2019, but we are going to go actually pull the file from the room and bring it in here real quick. There's something specific.
And I'm just looking for, let me tell you exactly what I'm looking for. I don't know in a case like this, they do it, but sometimes there's a provision in orders that say that if the parties either remarry or get married, that the orders go away. And I just want to make sure that this is not one of those orders.
What name would be specific on that order if it did have that?
It would. It would not be anything in particular. It would just be. I don't know that I've seen that where they have not been married. I've seen it in divorces. So I don't think it would be in this, but I just wanted to check because we can't incorporate the orders from the old case if they disappeared.
I think the last order in here, it shows, I think it was order suspending commitment. That was back on 2019. Yes, December 16th, 2019 was the last order in here. Order suspending commitment.
Ma'am, I need to ask you.
Yes, sir.
You said that you're having a hearing coming up.
So I submitted for a modification and I submitted for withholdings. So that was, again, when I filed for divorce, on the 13th, I filed that on the 14th.
Okay, and when do they expect that to get heard?
Actually, when I called yesterday, they, for some reason, still were trying to process the paperwork. And again, I wanted to get everything lined up for today as far as documentation, whatnot. But so they told me to just continue to follow up for up to 15 days. So.
Okay, ma'am. Here's the thing. What happens many times is that in a situation like this, if you have recent orders in the Attorney General's case, we'll just get a copy of the latest order in the Attorney General's case, and I can download that from the clerk's office and attach that and say, we're just going to copy this and go from there. There's part of the Texas Family Code that says if you come back to court within 1 year of when you have a court date on things like child support, child possession, that basically there's a presumption that you're just back to waste the judge's time and that you should lose. Okay. If we sign off on the divorce decree today, I think that it's going to raise that presumption that you should not be able to get anything changed for a year. So I think you would be better off. I want to go through with the property on this with you, but I think you would be better off waiting until you get that order finalized with the Attorney General's office, and then we can just take and attach a copy of that to this. But let me
So
see.
the divorce wouldn't be finalized today.
Correct. Because I think you need to be, that's what I would recommend doing. I mean, I can't give you legal advice, but just let you know that it's, at the very least, talk to the Attorney General's office. That rule may have changed. There may be a workaround that they can do with the Attorney General's office. But
And I don't mind putting off the Attorney General for a year if need be. I think right now priority is the divorce.
okay. All right. And did you hear what I told the folks earlier about the law presumes that everything a
Yes, Your
married
Honor.
person owns is community property? Okay, so
Yes, Your Honor.
this land at 301 Kerr Street, when was that purchased?
So it is not the property, Your Honor. It is strictly the manufactured home. That was purchased in July of 2014.
Okay. So see, that's actually his separate property. Now, there's also an automobile, a 2009 F-150.
Yes, Your Honor.
Okay, and you're being awarded a Nissan and a Dodge.
Those are both in my name only. So yes, Your Honor. So the only thing that we put on there is separate property was anything that was in both of our names, which was the home and the vehicle, and then the debt on the expedition.
Okay, what expedition?
It was the Ally Financial, I believe, that is listed
Okay.
under what he is taking.
Okay, and there has to be there needs to be a date that the two of you each pay your own debts after. And that was left blank. What date would be good to use in that?
I would give him one year would be sufficient for me.
No. It says after X day, someday you pay, each of you is supposed to pay your own debts. People will
okay.
use the date of separation. You don't have to.
We could do the date of divorce. So today.
And you're asking to have the previous name of Vega restored.
Yes, sir.
All right, now there's something called a BVS or Bureau of Vital Statistics sheet.
No, Your Honor, I did not complete that. That was not in my packet when I.
Okay, all right. I'm sure the clerk's office can get you a copy of it. And
Thank you, Your Honor.
typically they will ask that you fill that out before they'll give you a copy of your divorce decree.
Okay, Judge, I do have one that she submitted.
Oh, you've already done that. You just forgot.
Yes.
Is that the military affidavit?
No, in fact, I'm glad you said that.
I did submit that one as well.
Yes, no, that's if you're taking a default judgment.
Okay.
Yes,
I
I
tried to
have.
cover.
It's the one on the suit affecting the family relationship.
Okay, yes, I did do that. Yes.
Yes.
Well, my computer is just locked up. I can see y'all moving. I assume you can still hear me.
Yes, Your Honor.
Okay, I'm going to see if I can close down Acrobat. All right, I'm sorry. Let me see if I can get this filled out now. I had it filled out and my Acrobat locked up.
No problem, Your Honor. All right, Ms. Fagan, are you on a phone or a tablet? I am on a phone, Your Honor.
Okay, all right. I cannot send attachments to you, but
I can jump onto my laptop right now.
no, that's okay. I put this to the district clerk's office. Even if I send you a copy, it's just to look at. It's not signed by, or it's not file stamped with the district clerk's information. But they have that. You already have your Bureau Vital Statistics sheet. I will find I have jurisdiction to hear this matter. It's been on file for more than 60 days. There's a waiver of citation, in the correct format that's been on file for more than 10 days. The petitioner had been a resident of Frio County for 90 days and of Texas for 6 months prior to the time this lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born during the marriage. There were children previously born prior to the marriage who have a Attorney General lawsuit, which is taking care of their status, and I'm going to leave that in place. I'll find that proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And I will pronounce the divorce in open court. I'll restore the petitioner's last name of Vega, and any relief that does not appear in this divorce decree is denied. So this is a final appealable order. All right, ma'am, thank you for straightening me out on the kind of waiver that was, like I said, I'm looking at little tiny pictures and I could tell which one it was. Why it showed me a different one, I don't know. All right.
Thank you, Your Honor.
Wish you good luck, ma'am.
Thank you.
All right, and I just sent Frio County the Rule 11 in the case with, was it Mr. Salcedo, Jacob?
Yes, Your Honor. Attorney Berta Gutierrez here.
Okay. And I think it's a partial dismissal on Blackman.
Yes, Your Honor.
And I will post that to Ms. Kruger. Okay. All right, that has gone to Ms. Kruger. Should I have that?
Yes, Judge, I'm getting it pulled up right now.
And what date did that go to? I'm sorry. On Gutierrez, on the Jacob Salcedo.
April 8th, Your Honor.
April 8th. Thank you. When this crashed, I hadn't saved it in a while, so let me go back through. Okay, we ought to have a all right, I think we have about a 20-minute hearing in United Built versus Flores. And then we'll take a very brief break, and then we'll come back and we'll do the family law cases from Wilson County, I think, are next. We have an announcement on the case with Ms. Thomas.
Good morning, Judge. I believe we announced for 1 hour. It's for temporary orders.
Okay, and were y'all able to resolve thing in the,
No, Your Honor, we do not have an agreement.
all right, United Built Homes versus Miguel Flores?
Hello, Judge. I believe Mr. Smitherman and I are both here.
Yes, Your Honor. Patrick Smitherman, can you hear me?
Yes, sir.
Thank you.
Judge, we're on a traditional no evidence motion for summary judgment. United Built Homes received a substitute trustee's deed concerning the property in question on December 3rd of 2019, which originated from a foreclosure grounded upon Miguel Lopez Flores Jr.'s assigning of a deed of trust and a promissory note to United Built Homes. There's a cloud on the title grounded on two things that I could see, Judge. One is a warranty deed from Miguel G. Flores Jr.'s mother, Juanita G. Flores, to Miguel Flores, dated October 8th of 1996, and also the heirs of Miguel G. Flores, who is Miguel G. Flores Jr.'s father, filed an affidavit of heirship against this, I think this property, although I believe Mr. Smitherman has found evidence to show it may in fact be a neighboring property. But in any rate, because of these problems, there's been a cloud on the title, and we're asking the court to grant United Built Homes a final summary judgment stating that United Built Homes has a good, clear, and superior title to any of the potential Miguel Flores Jr. Heir or any of the Miguel Flores Jr. Heirs, which Mr. Smitherman is representing as the ad litem attorney. I have some evidence as to attorney's fees, but so does Mr. Smitherman. And I would think that Mr. Smitherman should be also heard as to his take on this motion for summary judgment. So with that, I would like to pass the chair to Mr. Smitherman.
Does it please the court?
Let me ask, were there people who were cited by publication, or how did we get an ad litem?
We had, the court has actually appointed an ad litem to represent any of the potential heirs of Miguel Flores. And so he has actually done a lot of work in contacting the potential heirs and so forth, none of whom want anything to do with this and don't contest this matter in any way, but simply don't want to hire counsel to appear in court on this matter. So from that sense, we've also had service of process taken out on any of the heirs that we could locate, and the process server has done a very diligent job, Judge, in trying to locate these people and contacting them and letting them know about this lawsuit. But essentially, they want nothing to do with this matter.
Okay, and all right, and I'm looking at the clerk's records. I see a bunch of affidavits of non-service.
Right. Most of the people that are the direct heirs and the people who signed the affidavit of heirship, I believe, are deceased at this time, which is another reason that the court has appointed Mr. Smitherman to be the ad litem attorney to represent these people.
All right. Mr. Smitherman?
Yes, Your Honor.
Go ahead.
Well, Your Honor, the court did appoint me as the ad litem, and in connection with my duties, I investigated to begin with the real property records, and it kind of looks what happened here. What the big problem was is that in 1996, a lady named Delfina Lopez Flores filed an affidavit of heirship, and as it turns out, Ms. Flores is the mother of Miguel Lopez Flores. That's the individual that entered into the builders and mechanics lien with United Built. Now, Ms. Flores filed Delfina Lopez Flores filed this affidavit of heirship, as it turns out, on an adjacent property to the property that's the subject of this quiet title action. And I think that's what led to some confusion here. The property descriptions are very similar. I've prepared an affidavit that I filed with the court that sets out the particulars. of the property descriptions and my real property searches. But I don't think that there is any sort of, as it turns out, cloud on the title. Certainly it appeared like there was at first. But regardless, I'm not really so much here to opine upon title issues. The court did appoint me as the ad litem, and United Built listed 10 different defendants. All these persons are the children of MF Flores, who is Miguel F. Flores, who I was appointed to represent the unknown heirs of, and his wife, Juanita Flores. So all 10 defendants are the children, and they're all deceased. And I verified that they were deceased through a pretty diligent obituary search. And I've described my obituary searches online in the affidavit that I've prepared and filed with the court. And I additionally, searched some probate records. I couldn't find any indication that they had died, but the obituaries are pretty convincing that all these individuals had died. I also had made a phone call to a lady that is the daughter of one of the defendants. Her name was Josephine Caballero. She's the daughter of Josephine Flores Caballero, and she lives near the property that's the subject of the dispute. She was very knowledgeable about her family history, and she confirmed to me that all the defendants were deceased. And I also sent a letter to the property, which was unreturned. So I'm convinced that the defendants are all deceased, and the court doesn't necessarily need me to opine upon title issues, but just as a licensed attorney in good standing in the state of Texas, it's very clear to me that United Built does have title, and that the property that was subject to this 1996 affidavit of heirship by Delfino Munez was an adjacent property. I found out it was an adjacent property. I didn't go visit it, but Ms. Caballero, the lady I talked to, told me they're less than a mile apart. And so this was just sort of a case of mistaken identity initially, but United Built has the right property, and for what it's worth, I believe they have title, and I don't think that there's anyone else that can claim title to that property.
And just so we're all on the same page, you're saying that you believe that the Flores affidavit of heirship that I'm looking at from 1996, that it correctly described a different tract of land, that they weren't trying to describe this property that United Built has title to.
That is exactly right, Your Honor. And
okay.
as Ms. Caballero, the person I talked to, the daughter of one of the decedents, told me, Juanita Flores, the grandmother, she was known to convey property that the family owned to her children. And so she definitely intended to convey that particular property to whoever was listed in there. Regardless, it's been bought by another lady at this point in time. The lady that currently owns the property that was subject of the affidavit of heirship is a lady named Maria Garcia. But originally, it looks like Delfino Lopez Flores was just stating that property had been conveyed to Anita F. Torres, who's one of the defendants. So it's just a mistaken of identity. Clearly, the property descriptions are for different acreages. They're at different locations. The tax records confirm that as well. I think United, it's good to go.
Okay. All right. Yeah.
Judge, I've submitted a proposed final summary judgment to Lori Riley for you to sign, but I think that we just have an issue of Mr. Smitherman's attorney's fees as the ad litem for United Built to pay, and I think that Mr. Smitherman may want to put on some testimony as to his attorney's fees.
Okay, now I think Ms. Riley stepped away, so if you could post that to me in chat, I would appreciate it on the order. And Mr. Smitherman, do you swear or affirm the testimony you'll give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. And Mr. Fox, do you have any objection to me taking judicial notice that Mr. Smitherman's a licensed attorney and that he is aware of what the normal fees are, or common fees are for this sort of work in this area?
I fully support you in doing so, Judge.
All right. Without objection, I'll take judicial. Man, my brain is just locked up, and I almost got sleep last night. Okay, go ahead, Mr. Smitherman.
Yes, Your Honor. My name is Patrick Smitherman. I'm a licensed attorney in good standing in the state of Texas. I've been a practicing attorney for 18 years. I devote probably 15% of my practice to probate matters. I was appointed as the ad litem by the court in this case to locate the known and unknown heirs of Miguel F. Flores. In connection with my my appointment, I've reviewed real property records and obituary records, and I've made phone calls to individuals, and I've mailed a letter. I will detail exactly what I did, but generally speaking, per my affidavit, I have reviewed the pleadings in this case. I've communicated with plaintiff's counsel, Mr. Fox, on multiple occasions. I've prepared correspondence. The correspondence is attached as Exhibit A, and I've researched the real property records of the relevant property, and as well the property that was adjacent to the relevant property that was sort of the source of the mistaken identity, as it were, in this case. I've also attempted to review death records and probate records and tax records in connection with the defendants and in connection with the property. I've devoted, as of prior to the hearing today, approximately 12.22 hours of my time. We've been on the Zoom call here for another 2 hours. I had a brief amount of preparation time prior to this morning. I believe that $150 per hour is certainly reasonable in Harris County, where I principally practice probate law. And so as of my affidavit, my fees total $1,846. I'm asking for, inclusive of today's time, $2,000. That includes fees and expenses. I've attached detailed billing records to my affidavit. They're attached as Exhibit B. If it pleases the court, I can go through each of these item by item, if that's what the court desires.
No, I'm happy with your attachment.
Okay, thank you, Judge. So that is the summary of my testimony. I believe the work that I've done was reasonable and necessary. I think the fee is reasonable and necessary, and I pass myself as a witness.
And Judge, if I may just give brief testimony as to attorney's fees. Yes, Judge. My name is Stephen Fox. I'm an attorney.
Oh, okay, let me ask. Is United Built asking for somebody else to pay their attorney's fees?
No, Judge. United Built is well prepared to pay these attorney's fees.
Okay.
And the order, by the way, that I've submitted orders United Built Homes to pay these attorney's fees to Mr. Smitherman within 30 days of your signing of the final summary judgment.
Okay. All right. So why do I need testimony on your attorney's fees?
I was just going to give some testimony as an expert as to attorney's fees in support of Mr. Smitherman's attorney's fees, and just to award, and also to award attorney's fees for me, but against United Built, that United Built would take care of the fees.
Okay, I mean, well, how come you're not going to just send your client a bill?
Well, I have, but it's just something that we normally do. But if the court doesn't want to award me a fees, that's not important. But I do, as a licensed attorney in the state of Texas, and I've been licensed since November of 1984. I fully support Mr. Smitherman's award of attorney's fees as the ad litem. And I would also ask for an award of $2,100 as my fees, because I've done about 14 hours of work. And I believe that $150 an hour is a reasonable and necessary customary fee for the case of this type and complexity in Atascosa County, Texas.
All right, sir. And are you asking to have, you say that United Built Homes is awarded court costs herein. Do you mean that they're awarded against the plaintiffs and you're trying to get a recovery from the plaintiffs?
Not from the plaintiffs.
From the defendants?
Not from the defendants, Judge. Just as an award. But we're not seeking any type of a money judgment against the defendants in this matter, as they are all deceased anyway. This is just an in rem a summary judgment as against the land, which United Built holds title to.
All right. And you were asking for $2,100?
Yes, Judge, and I fully support the award of what Mr. Smitherman is asking for. I believe it's $2,000. I believe that's more than reasonable and necessary and customary for the work that he's done in this case.
All right. And you swear or affirm that's all true and correct?
It is, Judge, and I'm also an officer of the court, so I'm bound to be open and truthful to the court at all times.
Okay. Do y'all have any cross-examination of each other's testimony?
No, Your Honor.
No, Judge.
All right. I'm changing the sentence that says that the plaintiff is awarded its costs to say that they're taxed against them. Okay, I will grant the relief prayed for with that change.
Thank you, Judge. How could I get a copy of the signed final summary judgment?
You'll have to get the file stamp copy from the clerk's office. I expect that you'll get that automatically whenever they e-file it, but I will post a copy of the judgment here to you in just a moment.
Thank you, Judge.
Thank you, Judge.
Okay, that has just been posted to everyone. Okay. All right, we're going to take a 15-minute break and then we'll come back and we'll do the Messick case from Wilson County and whatever else we have left. We'll see y'all in 15 minutes.
Thank you, Judge.
All right, does anyone have an announcement for anything short?
Your Honor,
Your Honor. In the O'Connor case in Frio County, I don't have my docket in front of me.
Yes.
We have agreed to a Rule 11 for this to be reheard, temporary orders to be reheard on April 8th,
Okay.
as well as the current visitation order remain in effect until then. And for Ms. Cantu to submit to a drug test within 7 days of today.
What sort of drug test?
A fingernail panel, fingernail and toenail drug panel.
Okay. All right. And Mr. Russell, is that your agreement, your client's agreement?
that's the agreement. There's just a few other things. There was a list of items that she's going to pick up as well from the home. And I believe also that the calls are going to be by Zoom instead of calls. They're going to be, or by phone, they're going to be by Zoom.
Okay. All right. And then have you reduced that to writing yet?
Not yet. I think opposing counsel is going to be drafting a Rule 11 agreement today.
All right. So we're just going
I
to, before 8.
just sent it to you, Mr. Russell.
Okay, great.
I'm sorry, that broke up for me.
Did you send it to my email address? I don't see it yet.
I did. I just sent it just a minute ago.
No, we'll get that signed as soon as I receive it.
All right. Thank you. All right. I'll reset you for 4-8.
Thank you, Your Honor.
Thank you, Honor.
May we be excused?
Yes.
Thank you.
That's it.
Okay. Calling 2367 in the matter of the marriage of Messick.
Yes, Your Honor.
And
Jennifer White for Dina Mazak.
Alan Manka here for Roy Mazak, Your Honor.
Mr. Manka, it looks like you are the petitioner's attorney. So what, if anything, do you believe is set today?
Well, Judge, you may recall Ms. White presented an order to you before I appeared.
All right, and let me just state for both the attorneys, that was somewhat later in the day. I made inquiries. My inquiries led me to believe that Mr. Manka's office had full knowledge that everything was set and when it was set, and that we had heard nothing from them. So I said, well, all right, I guess he didn't care. And I signed the order. And within an hour or so, I had a second report from the coordinator's office that said, no, actually, Mr. Manka's office had contacted them to say that he was not in agreement with like temporary orders or whatever it was, and that he would be along later in the day, which I believe he was. So I had said I would take back whatever it is I had signed. I don't know if I've done anything to officially do that or not. Okay.
I filed a request as you requested, but I didn't attach an order because I don't know what the procedure would be on that. Do you just want an order saying it's withdrawn and we start from scratch?
That's fine for me, but let me ask, what are you, if anything, do you believe is set today, Mr. Manka?
I don't know, Judge. I got this email from Lori, from Ms. Riley saying that we had a hearing set today, and that's all I know. I got this Friday without any other notice of any kind, and so I'm here.
All right, Ms. White, what are you as a respondent's attorney? Are you advocating is set for hearing today?
This is what my belief is, besides the fact of the misrepresentation to the court from Mr. Manka, but this is the 6th time we've been here. My understanding is when we were before you February 1st, the temporary orders were signed based on an agreement that we had back in August, which Mr. Manka was provided the transcript. I tried to put it in the chat for you, but it was protected, so I'll have to email it. We then had a second hearing on December 9th to try to get these temporary orders entered. Mr. Manka and I had an agreement. He had 4 issues with the temporary orders. We explained 2 of them.
Ma'am, all I want to know right now is what is it that you believe is said today?
His request to withdraw the temporary orders and or make changes to them. When we were heard during the freeze, Mr. Manka had a few changes, a few requests to change them. We said we needed a hearing, and then your court reporter's electricity went out.
Right.
So you reset us for a week or so, but they set us with Judge Ellison, and Judge Ellison had previously said it needed to be heard by you. So then we had to reset for today with you.
Okay, so where does that leave us?
Based on what I believe, it's whatever the few changes that Mr. Manka was asking to be made to the temporary orders that were presented to the court February 1st.
I believe properly, the court needs to enter an order setting that aside. And then if you want to discuss the temporary orders, we can do that again, Your Honor.
You know, there was an agreement.
We're going to get this resolved today. All right.
I believe I sent you a copy of the signed orders.
So. And it looks like I signed a bunch of subpoenas for something or another.
Yes. That was the same day, February 1st, I believe, Judge.
Okay. So, Mr. Manka, what are your objections to the temporary orders that have been signed?
Do you have it before you there, Judge?
I have temporary orders signed February 1st. Is that?
Yes, sir.
So
If you go to, if you want to go through these piece by piece, Judge?
Okay, have you and Ms. White had a chance to go through them piece by piece?
Yeah, I told her, and she says she's not going to change it. She wants you to rule in excess of what our agreement was.
Okay, and now, Ms. White, you have indicated that you have a transcript from something or another, a hearing?
Yes, sir.
The
From
ruling.
the original temporary orders hearing back in August.
Okay,
It wouldn't let me attach it in the chat. It said it was protected, so I'd have to email it.
okay, and did you email that to the coordinator?
I have not yet. I didn't know which email you wanted me to send it to, you directly or,
I sent you an email address in chat.
oh, I must have not seen that. My apologies.
Let me ask Norma, are you able to open up the email that says coordinator?
Yes, sir, I am.
All right.
Let me see.
And what date was this?
August 17th, 2020.
I'll be right back.
I just sent it, Judge.
Okay, I've got the transcript. What's the first page I need to flip to?
Up to page 4, Your Honor.
You said page 4, Alan?
Yes.
Okay.
That paragraph is our whole agreement, Your Honor. That's it, and that's all.
Okay, I don't know what, we're looking at something different, Mr. Rankin. I'm looking at the temporary orders that I signed on the 1st of.
Oh, the orders. Yes, sir. I thought you were looking at the transcript. No, sir. On the orders, we're looking at page 8. Paragraph number 4.
Okay.
Roy Mazak is ordered to pay Dina Mazak 100% of multi-health insurance premiums for the child. That is a question. Of course, we're responsible for support the child and to provide medical. However, we did not agree to give the respondent the money. The problems in the past between these parties make that a very problematic. And we did not agree to it. And Ms. White asking the court to add that to the agreement is improper.
Your Honor, if I may.
Yes.
We request that it be paid back to my client because Mr. Menka's client canceled the family's health insurance in July, which is after the date that the divorce was filed. So my client had to go and get the insurance again for the family through the same company. And she's afraid that if if she doesn't make sure it gets paid, then it won't get paid, and we'll have to deal with this all over again. And everybody has health issues, including their son, who is still a minor. So my client has been paying it directly to the company, and she asked that she be reimbursed that money because of what Mr. Manka's client did back in July.
That's a fact issue, Your Honor, and that's a very small part of the facts. First off, the lady had Medicare at the time of this temporary orders hearing, and so the child
Okay,
was
who's
entitled to
paying,
his own
who's
benefit.
paying for the child's health care insurance right now?
My client is.
Nobody. Well, she may be. We requested several times to get the social security number for the child so we could put him on our coverage. That was refused on a number of occasions, and and the policy lapsed.
Which is incorrect, Your Honor.
Okay. What's your next issue?
Then we go to same issue on page 9, number 6, the same language on dental insurance. She wants us to pay that lady. And you should know that this lady had Medicare, canceled it to save the $138 that it was costing her out of her Social Security, and signed up for an insurance policy of almost $1,000 a month.
Your Honor, the Medicare just has always only covered my client. The children have never been on Medicare. The kids have been on this same insurance policy since 2005. The children have never been on my client's Medicare. And my client canceled to cover her own self because Mr. Manka's client hasn't been paying things, and she couldn't afford she had to find the $138, so she canceled it so she could have that money to pay bills.
Our obligation under the code is to provide medical insurance, not to pay the lady, Your Honor. And as you can see, it's not, none of this is in the agreement. We're just talking about our obligation under the code.
Your Honor, December 9th, when we were here the first time to enter these orders, Mr. Manka agreed to these terms. The 4 issues he had nothing to do with the health insurance. And we reported back to the court that
what's the next one?
This is probably the 6th draft of these temporary orders, Your Honor, and everyone changes.
What's the next issue that you have, Mr. Manka?
Then we go to page 14. And this is where the transcript becomes important.
Okay.
Page 14, the very first statement, internet subscriptions. If you have the transcript before you, you will see that we agreed to provide internet. We didn't undertake to pay for any subscription services that she decided she wanted.
And Your Honor, briefly, I've explained this to Mr. Manka on several occasions. We listed the name Alamo on the page before, the bottom of 13. Alamo is the internet provider. Hulu is the cable provider. So if I it's not a separate subscription. It is just being specific on the 2 bills. Alamo provides the broadband internet and Hulu is the cable. It's not an additional subscription like Netflix or anything like that. That is who provides the cable.
That is not correct. And if you know anything about the internet, Your Honor, you know that the Netflix, the Hulu, all those are subscription services that cost more than the basic cable service. Cable service is provided by Spectrum.
That's the only bill she receives for cable is the Hulu bill, which is
And it
approximately
shows Hulu on it.
$75 a month, which is what we told the court back in August.
Subscription.
No.
And just so the court knows, you can get cable through these other providers to lower costs on your cable bill, as whether it be Spectrum or DirecTV or whatever. And Your Honor, I'm looking at the temporary orders. I mean, I must have misspoke or whatever because it says internet subscriptions, but it really is cable internet provider, Alamo, and Hulu is what it should state. I was trying to be specific for the
As
part.
you Google up Hulu, Your Honor, it says Hulu is an American subscription video on-demand service fully controlled by the Walt Disney Company.
On demand, which means
This
you
is
can
not-
act as live TV as your cable.
That's right. It is not a cable provider.
Okay. Is that who the parties had? Did the parties have a cable provider whenever Mr. Messick left?
Yes, Your Honor. And we agreed to pay the internet there.
It was Hulu and Alamo. When Mr. Manka's client left, he canceled them both, and my client just opened them back up in her name. It's the same exact plan that they had when he was living there.
I don't believe that's correct. They're here to testify, Your Honor, if you want testimony.
Okay,
I
and your
believe
next
Mr.
objection?
Sir?
Your next objection?
Next objection, we go to number 4, family cell phone plan. Talking about what was in effect at the time of the hearing. There was no family cell phone plan. It's not in the agreement, and you heard no evidence on it. So again, she's asking you to do something in excess of what she should be. At the time of the hearing, the family cell phone plan had been canceled by the respondent. She got her own cell phone plan.
That is not correct. And in the transcript, it does say that he is to pay this cell phone of $250. And what I've explained again to Mr. Manka, and he was fine with in August and December, his client again was trying to cut off the service.
Okay, let me just say what my ruling is going to be on everything where there's a category and a number. It's ordered, he's ordered to pay that capped at that number.
Perfect.
So I don't
yes.
they call it. If she can find a $10 a month cell phone plan, then it's $10. If she finds a $1,000 a month cell phone plan, it's $250 or whatever the number is that was in the transcript.
Then we go on to number 7, First Mark Credit Union.
Okay, what page?
Same page at 14 on the temporary orders.
Okay.
Just following there, number 7 below the family cell phone plan. First Mark Credit Union, we have no idea what that was. We suspect this is a loan that the respondent secured after the separation. It's not in our agreement and we're not willing to pay it. And so since there was no evidence.
Oh, okay, and Ms. White, your response is?
Yes, Your Honor. This is a pandemic loan that the parties took out in Mr. Manka's name while they
Mr.
were.
Manka?
We've
No.
explained this to them, and as a matter of fact, it's going to be paid off. He's been paying it. Mr. Manka's client's been paying it directly to First Mark, and if I'm not mistaken, it'll be paid off this month or next month.
No. And then number
Okay, well,
9,
what do you mean, no, Mr. Manka?
I don't believe that's correct. I don't believe he has been paying it. He has been giving a large sum of money to the respondent, and what she does with it, I'm assuming she's paying some of these bills.
He's been paying all the bills directly, and the only time he gave my client any money was just a week ago when he finally reimbursed her for about 5 months worth of utilities that she paid for.
Okay. So where does it say in the transcript that he's supposed to pay the First Mark bill? I take it does not.
I'm having a hard time reading it. It does not, but I know we discussed it, and we discussed it again December 9th. And they were fine with it December 9th.
All right. Your next objection, Mr. Manka?
Then we go to families' health insurance premiums. As I said, at the time of this agreement,
what page?
was on same page, just number 9, right below the First Mark loan, number 9. Page 14, number 9 at the top.
All right, go ahead, sir.
And at the time of this agreement, at the time of the hearing, respondent was on Medicare, and we did not undertake to pay any family health bills. We understand the obligation to provide medical for the child. That's it. There's nothing in the agreement. There's no evidence before the court. That's not proper.
Again, Your Honor, this was discussed in December. They were in agreement with it. His client canceled the family plan. It's actually cheaper than it would have been had he kept all of them originally. Like, she's actually saving him a few $100.
Could I just state for the record, there were no agreements in September, October, November, December, whatever she's saying. We've been working.
I have video of that when we came on and said, we have an agreement. I'm making the 2 changes to what was proposed, sent to the court. I'm making them, which Mr. Manka requested and we agreed on. And I sent them to him and he never would sign them.
As I said, we probably had 6 different versions of these temporary orders. Everyone changes.
No, it won't.
Okay, your next disagreement?
Again, right below number 11, debts in petitioner's name. Again, not agreed, no evidence. And the danger is, we understand this lady's been going out applying for credit cards, signing.
Back to that, Your Honor. He has no idea my client has a name.
Signing my client's name to.
Okay, all right. So, Mr. McCon, we understand what your objection is. Ms. White?
You know, I put the same thing in my clients. That's standard language. If they've opened up anything since then, we don't know what he's done and what she's done. It's standard language. Anything else that we forgot, we put in there. You pay for whatever your expenses are. She's paying for hers.
That's not what it says. It says on that date, we are to pay debts in our name. We are not agreeing to that.
And it's just standard form language, Your Honor.
Okay, your next objection?
Going to page 15, next page over, page 15 of the order, severance pay. In the transcript, you'll see that we agreed to pay any severance package that my client might be entitled to over to the respondent. She's adding language in here from any employee benefit plan. We're asking that those 1, 2, 3, 4, 5, 6 words be stricken.
Again, this was discussed in December. We made one change and removed one word that he asked, which included the word bonus. We took that word out. This was the language we agreed to. And I mean, where else is a severance package going to come from? It's going to come from some employee plan benefit that he had.
Severance package has a particular meaning. Other benefit plans are not included.
It doesn't say other.
We ask that you strike those 6 words after severance package.
Yeah, I know. Something else. No, that might be.
And what sort of employee benefit plans does your client have that he's wishing to make sure it doesn't fall under this?
No, Your Honor, but we have no idea what they might come up with because he is disabled. He's been on a disability for some time. He's dying of cancer, so he's got medical benefits that are coming in. All our offer was severance package. When the respondent found out that my client was going to be laid off because he just couldn't perform the job anymore, she starts demanding his severance package. We said there is none. We go on and on about that. And so finally I said, take it. Any severance package you can find, you can have it. Now she's expanding this to some other language that we did not agree to. We will give her any and every severance package she can come up with, but other benefits he may be entitled to, we did not agree. And at final trial, if there's such that needs to be divided, that's a separate issue.
Yeah, and Your Honor, it doesn't say other benefit plans. He's only worked for Pioneer Drilling. They've been married for 20 plus years. Like,
It says any.
All right.
from any. Not any other.
Okay, all right, your next objection?
Going to the top of that page, number 1 at the top of that page, right above severance package. In number 1, the next to last line where it says, and if found, medical and dental records. The and should be at the beginning of this list, if found. That was our agreement. Any of this stuff that we can find, we'll give him. This orders him to deliver things that he doesn't have. And our agreement was if found. You can see in the transcript, some of these things are listed, and it's including his teeth. Where our agreement was that if any of this material could be found.
Your Honor, if you look at the transcript, it says that he's going to return some of the quilts as well as wife's journal. And if he finds any of wife's medical and dental records, he will return those. That only applied to her medical and dental records. As a matter of fact, he's already given her back a quilt, I believe. He has them, and we have text messages to show, and he taunts her with it.
Okay, and okay, your next objection, Mr. Nathan?
That's all we have, Your Honor.
And Your Honor, I just want clarification on one issue. When you were saying the specific dollar amounts that were listed in the transcript, on the utilities part, that was the only one. It said approximately 400 because they kind of vary between the two, especially like with this freeze, they had a pipe that busted that they had to replace. And so the bill's a little bit more than like what average would be. That's the only question I have on the, we listed approximately $400 a month for the utilities.
She's got thousands of dollars every month to spend, Your Honor. And there is unaccounted for $14,000 of the party's savings that we've demanded explanations and are getting stonewalled. She has plenty of money to pay the little bit of excess over what we're paying.
All right, that's enough. And let me go back and look at this for a moment. All right, and did the family members have dental insurance prior to the divorce?
Yes, since 2005.
Mr. Knight, your clients in agreement that they had dental insurance?
I don't recall that specific, Your Honor. Mr. Messick, did you have dental insurance before this was filed?
Yes, we had insurance before I got released, and everything had to go on Cobra, and she would not give me any.
All right. The answer is yes.
All right, I will accept Ms. White's language on the page 8, paragraph 4 dispute and the page 9, paragraph 6 dispute about dental insurance and health insurance. The other way around. On all the bills that have a number, except utilities, I'll cap that at whatever that number is. And the utility bills or whatever the utility bills are. On the first mark, I don't know what that is. I don't know who's been paying it. Not going to put it in the temporary. Well, I don't find that it was agreed to in the temporary orders. I don't find that the family insurance was agreed to in the temporary orders, so I will sustain Mr. Mankin's objections to those. I'll sustain his objection on paying debts in his client's name. I mean, they need to be paid, but I'll sustain that because if that wasn't litigated previously, I will strike the language that he objected to on the severance package. I'm not sure what else that would be, but I think that my understanding of a severance package would contemplate an award for payment, for earning.
Right.
And not something else.
Right.
So just the employee benefit plan, take that out?
Yes, whatever language he objected to.
Okay.
And I will overrule his objections to the if found language. The transcript shows it was represented that he had quilts, plural, in her journal, and they should have been returned already.
Judge, can I make these changes and send them to you whether Mr. Manka signs them or not? This is what happened in August and December.
Okay. How long will it take you to make those changes?
30 minutes.
All right.
That'll just precipitate the need for a rehearing, Your Honor. It's up to you.
Okay, so why don't, let Ms. White make the changes. Go to lunch if you want, be back by 1. So she has plenty of time to make them, and we'll have whatever hearing we need this afternoon.
Your Honor, I have, as I said at the call of the docket, I've got a hearing this afternoon in Bandera County. I'd like to be excused to go to that. Not go, I mean, we said.
How long will that take?
What time is it?
It's at 1 o'clock.
Okay.
And it's discovery disputes, piece by piece, just not like this, completely different, but piece by piece going through responses to discovery, as long as Judge Emerson will put up with us.
Okay.
Do you think that you would be allowed a break to finish this up, 5-10 minutes?
Right. I'll allow Ms. White, email this to Mr. Manka today. I will give you until noon tomorrow, Mr. Manka, to email to the coordinator your objections.
Perfect.
And I'll sign it and I'll make a decision based on submissions.
Perfect.
Thank you, Your Honor.
All right.
And send it to the coordinator email?
Please, and you are excused.
Thank you.
Thank you.
Go back and look and see what we have. Let's reset on request on. So you still have an hour in the Stanteen Jr. case?
Yes, Your Honor, and we may be able to finish within the hour, Your Honor.
Okay,
And I do have a mediation that's set at 1:30 today, but I
All right.
told them that I would be there as soon as I can, so I'm good for now.
Okay, so let me look. Do I have anything left in Frio County?
The only one that I was asking on, Judge, was that very first one, 0807-00147. Grady Roberts announced something, but that's when I was having issues.
He announced they had it all worked out. and she was going to go to his office and sign it. So hopefully that will occur.
Okay, and then he'll just submit it.
Hopefully.
Okay, because he left as well.
All right. So all we have left is this, and then at 2 o'clock, the lock bond matter.
We're
Okay,
done with Atascosa, Judge?
I think so. Let me go back and pull that.
I got
I haven't had it
the
open. I haven't had it open since I had to reboot my computer.
I got the proposed summary judgment that you
Oh, yes,
signed
you only had the
for-
one case. Yes, no, I signed that. So Atascosa is finished.
Okay. May I be excused, Judge?
Yes, ma'am. Was there an add-on in one county? No, it was just regular docket. Okay, yes, ma'am, you're excused. Thank you.
Okay, thank you, Judge.
Judge Wilson, would you like for me to stay on or just let Grady Roberts e-file or?
I'm happy for you to take off.
Okay, thank you.
Hopefully he'll e-file that.
Thank you.
Hold on a minute. Let me ask, what are the live pleadings in the Stanteen case?
The live pleadings right now are for today, the motion for temporary orders, Your Honor. We also have a motion to transfer from Wilson County to Hayes County. I believe a response has not been filed, but I have not checked my mail since Saturday, so I'm not sure if Ms. Thomas has sent anything in, and I don't know if she's filed anything with the court since last Saturday.
I can speak on that. Yes, I did. I sent a response in just Friday, actually. I mailed it off. Yeah, we're supposed to sign for it. Same thing for the courts as well. But I would also like to reset this hearing.
Your Honor, we've been here since before 9 o'clock. I am contracted with legal aid to represent Ms. Hastings, so I'm not inclined to agree with this continuance. When we met to confer earlier, she informed me that she's ready to proceed. She had her documents that she was going to show you today, so I would ask that we proceed today. I've got 2 witnesses that have been with us since before 9 o'clock. We're ready to proceed, Your Honor.
Ms. Thomas, this is just temporary orders hearing. So we will proceed, and let me ask, first of all, Ms. Okay, and your client is LaKendra Hastings?
Yes, sir.
All right. Let me ask Ms. Hastings and Ms. Thomas to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and what other witnesses do you have?
I've got 2 witnesses, Mr. Franklin and Jeremy Thomas. I believe they're in the,
Yes, Jeremy, both of you to unmute, and Jeremy Thomas, would you start your video? Well,
Let's see what happened.
let me go ahead and swear you in, Mr. Franklin Thomas.
Yes, sir.
Do you too solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, and I'm gonna ask you to speak up a bit too, in your name.
Yes, sir. Franklin Thomas.
Okay. If I call you Mr. Franklin, forgive me, the longtime county attorney in Atascosa County was Thomas Franklin.
That's all right.
All right. Okay, so, and so let me flip back. Now there's a final order from June 19th, 2017. Is that the order that's going to be, that you're asking to have changed?
yes, Your Honor.
Okay. And what exactly are you asking to have changed
For the temporary orders or in the final order, Your Honor?
on the temporary orders?
On the temporary orders, we are asking that Ms. Hastings be appointed the temporary managing conservator of Edward Stanteen Jr. We're asking that the possession and access be modified in the best interest of Edward. And we're also asking for a restraining order or stay away order.
Wait, hold on. All right, Mr. Jeremy Thomas?
Yes, I'm here.
All right, can you stop walking?
Yeah, I'm getting to my car because I'm currently at work right now, but I'm about to get in my car.
Okay, I'm going to mute you until you get there.
Thank you, Judge. So lastly, we're just
Okay,
asking.
hold on. Let me just go ahead and swear him in. All right, I'm asking, all right. Ms. Thomas, do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. All right, and your name?
Jeremy Thomas.
Okay, and I'm going to mute you now, sir. All right, go ahead, Ms. Aldrich.
Yes, Your Honor. Lastly, we're just asking for a stay away against Miss Erica Thomas. So we're asking for temporary managing conservator to suspend the visits or restrict the visits, and also a stay away, Your Honor.
All right, and what visitation does Erica Thomas have right now?
Right now, she gets the first, third, and fifth weekends of the month pursuant to that final order at Kids Share. And she has not made her visits in February, nor has she made the last visit, Your Honor, and she has missed 18 months in a row immediately after that order had been signed.
Okay, and what are you going to ask me to do today, Ms. Thomas?
I don't think she has any pleadings on file, Your Honor.
I understand. I'm going to ask her to unmute, though.
Hello, Your Honor. I have been having my visits. They just haven't been cooperating with my visits, sir.
All right, so are you going to
I
be?
have the police reports and everything to prove it.
This is not time to testify. So you're going to be asking me to not do what they're asked, what Ms. Hastings is requesting. Is that correct?
Like currently I have rights to my visitation, so I'm going to continue my visitation. Those
Okay,
are my
so-
rights currently.
Okay, so, all right.
I have to sit here and pay child support. So if I have to sit here and pay
Okay,
child
ma'am,
support, I have
ma'am.
rights to visitation.
Okay, that's
Okay.
enough. All right, everyone's aware of your position now. Okay. Ms. Aldrich, your first witness.
I would like to call Jeremy Thomas, please, Your Honor, if you can unmute him.
All right, Mr. Thomas, go ahead.
Yes, sir, Your Honor.
Okay, do you have any other electronic device going there, Mr. Thomas?
No, sir, I just have my phone.
Do you have your door open?
Yeah, is that better?
Yes, because we keep getting wind noise. That's better. Go ahead, sir.
Okay.
Your Honor, Mr.
Okay.
Thomas has been sworn.
Yes.
Okay.
He has.
Jeremy Thomas, can I call you Jeremy?
Yes, ma'am.
Yes, my name is Pam Aldrich and I represent Miss Hastings. I think you were aware of that. Can you state your name for the record?
My name is Jeremy Thomas, Jeremy Glenn Thomas.
Okay, and how are you related to this case? How are you involved with this case?
I'm actually the I have actually conservatorship for Edward Stanteen right now. I'm also the uncle of Edward Stanteen.
Okay, and how are you related to Erica Thomas?
You're the what?
That is my sister.
Okay, I didn't, you said you were something, you're the what of Edward Stanteen?
I'm the uncle of Edward Stanteen, and I'm the sister of Erica Thomas.
All right, thank you, sir.
Okay,
Go
may I
ahead.
share the screen, Your Honor?
Yes.
Okay, Jeremy, I'm going to show you a document. Your Honor, did that show up the final order in suit affecting the parent-child relationship?
Nope.
It did not show up?
No, what we're seeing is, it looks like a index. It says petitioner's exhibit 1, but the document itself did not show up. You go, that's better.
Okay, there you go.
Okay, Jeremy, what is this? Do you recognize this piece of paper or this document?
Yes, ma'am. That's the court documents from Wilson County.
Okay, and this was entered on June 20th or around that date of 2000?
Yes, ma'am. Yes, ma'am. That's correct.
And this is in regards to Erica. And who is Edward Bailey Stanteen? Who is that?
That is Edward's dad. That is Junior's dad.
Okay, and this was a CPS case, correct?
Correct. Yes, ma'am.
And when this case started, how old was Edward?
It wasn't even 1 yet.
Okay. And at the end of this case, the father's rights were terminated. Is that correct?
Yes, ma'am.
Okay, but Erica retained some of her rights. Is that correct?
Yes, ma'am.
Okay, and here on page 3, it shows that you were appointed as the sole managing conservator.
Yes, ma'am. That's correct.
And also at 7.4, it says that you have the exclusive right to designate the primary residence of the child within the state of Texas.
Yes, ma'am. That's correct.
Okay, and you're here today to ask the judge to allow Edward to live with Wendy.
Yes, ma'am. That's correct. Yes, ma'am.
Okay. And we're going to go down here to page 4. Here's the mother's right. She was appointed possessory conservator. Is that right?
Yes, ma'am.
Okay. So her rights were not terminated.
Correct.
All right. And also I see on page 7 down here, there are some injunctions that she is not allowed to, for certain people to be around Edward and also not to be 100 feet of you. Why was that stay away put in place at that time? Do you know?
Because there was a Facebook post. We still have the Facebook post. There was posts where Erica stated on Facebook that she would come into the house and she would kidnap her child out of our care. So that was one of the reasons why that was also placed in order, and it was also for the safety of Edward Stanteen Jr.
Okay, and why did they felt the need to protect Edward Jr.?
Because Erica's Edward Stanteen Sr. was he's actually a convicted criminal, and he has histories of breaking into people's houses and stuff. And then also at the time, Erica was still talking to Senior at the time of the CPS cases was going on, and so we felt that it was for our safety and for Junior's safety that we placed some restraining orders.
Okay, has she abided by this 100 feet stay away?
As far as I know, yeah. But other than the incident they just had in San Marcos, where she made a law for pretty much just lied and stated that with the law enforcement in San Marcos.
Okay, are there any other concerns right now in regards to? I'm going to call him Junior. Is that all right? Since we have an Edward.
Yes, ma'am.
Okay, so have there been any other concerns with her threatening people or threatening Junior?
Yeah, she still posts stuff on Facebook. There's just recently I seen that she had posted something on there about a couple of days ago. So you know, and I do feel like there's safety concerns for Junior if he does go back. One of them is actually really, and like I said, I'm doing this for the best interest of Junior, and one of the reasons why I really want him to go back with Wendy is because he's so mostly attached to Wendy. You know, there's he is just, you know, it would be an emotional breakdown if he didn't stay with Wendy.
Okay, I'll ask you that a little bit.
Oh, okay, I'm sorry.
Okay, that's okay. I just want to get through this order to show the judge what it actually says. I'm going to go down to the attachment down here. in regards to her visitations. And this here says she gets the first, third, and fifth Saturdays of the month. Is that correct?
Correct. Yes, ma'am.
For 4 hours,
Correct.
but it's supposed to be supervised at KidShare.
Correct.
Okay. And are you aware of her making all these visits since 2017?
No, she has not made all of them visits since 2017. Right after the case had happened, there was an 18-month period. Me and Wendy, we had hired an attorney. The attorney, I don't know what happened with the case. You know, she never looked into it. But when we first closed the case out, there was an 18-month period where Erica did not go to visitations, no nothing. And me and Wendy, the day after we got the papers, we went up there to KidShare to get everything finalized and everything. And all they said is Erica would just have to call up there and just whenever she's ready to make a schedule appointment, that's all she had to do. So we put forth the effort to hurry up and get the visitation started right after the court case had happened. But there was a whole 18-month period where she didn't even contact KidShare.
Okay. And you're also aware that she missed all of February, correct?
Yes, ma'am, and of March. Well, she hasn't had one in March yet, neither.
Okay. And the way KidShare works, she would need to set that up. Is that what I'm hearing?
Yes, ma'am. She'll set it up. We'll set it. We'll call in, you know, or they'll call us and schedule a visit, and then they will call Erica and they will confirm with Erica, and then so that's how that will go. They will confirm with Erica. They'll confirm it, and then once it's confirmed, then you know that's when the visitation is set.
Okay. And when they called you to bring Junior, have you at any time refused to bring him to these visits?
No, we ain't never refused. We canceled. We would have to cancel, and we would call KidShare way ahead of time. We would cancel, and we had documentations and doctor notes of the reason why the visitation was canceled.
Okay. And due to COVID right now, KidShare is doing remote visits. Is that?
Yes, ma'am. They're doing Zoom visits. Yes, ma'am.
And it's your understanding that she's making these police reports because she can't see him in person?
I'm assuming so.
Okay. And then lastly, the attachment B here is in regards to her child support, which she's been ordered to pay $195 a month. Has she paid that to you since 2017?
Honestly, I probably got maybe about 3 payments from her. I probably got about 3 payments, and in them 3 payments wasn't even I haven't even had a full month of her paying $195 in a month. Now, due to the fact they're garnishing her income taxes, I was receiving I did receive her income tax, and I also received some of her first stimulus check.
Okay. I'm going to show you another exhibit. This is marked Petitioner's Exhibit 2. Can you tell me what this is?
That's temporary guardianship.
Okay. And is this your signature at the bottom? Is that your signature right there?
Yes, ma'am, that's my signature.
Okay. And what does this affidavit mean to you? What are you actually doing?
That means I pretty much have all of the rights for him to go to the doctors, for him to for him to get enrolled into school and stuff like that, and to take care of him.
Okay. And is this a guardianship affidavit that you are actually allowing Wendy, Miss Hastings, to take care of Junior?
Yes, ma'am.
Okay. And you're allowing her to make all the health and emergency medical care decision, educational decisions, travel, and other decisions that would be in his best interest. Is that what you're?
Yes, ma'am.
And you completed this with the assistance of the Department of Family and Protective Service. Is that correct?
Yes, ma'am.
Okay. And at this time, you want to convert that quote unquote guardianship into a conservatorship so she can have those protections.
Yes, ma'am, that's correct.
Okay. So, Your Honor, at this time, I'd like to admit petitions Exhibit 1 and 2 that was just presented.
All right, well, Exhibit 1 is already in the court's file. I'll take judicial notice of that. That's above there. And Ms. Thomas, do you have any legal objection to the admission of the guardianship affidavit? Ms. Thomas, I don't know if you're trying to speak, you're muted.
Oh, say again, sir?
I was talking to Erica Thomas.
Oh, okay.
Hello, sir.
All right, do you have any?
Your Honor.
Yes, do you have any legal objection to the admission of the petitioner's exhibit number 2, which is the guardianship?
Yeah, I do, Your Honor. It's crazy. I knew about that investigation that was going on. The CASA worker on the case
Okay, ma'am.
that y'all saw on the order.
Ms. Thomas. Okay, the only thing I'm asking right now is, do you have an objection to the admissibility of this piece of paper? I'm not asking if you agree with it.
Yes, I do.
What is your objection to the admissibility of the petitioner's exhibit 2?
Well, the reason why I'm objecting it to it is because I want to let you know currently I have a 4-year-old boy in my custody. He is the brother of.
Objection, Your Honor.
All right, and Ms. Thomas, again, I'll find that's not a legal objection. So without a legal objection, I will admit petitioner's exhibit number 2, and you'll have a chance to speak very shortly. Go ahead, Ms. Aldrich.
Thank you, Your Honor. Mr. Jeremy Thomas,
Yes, ma'am.
tell me a little bit about your relationship with Wendy. How long have y'all been together?
Me and Wendy, we was together for 7 years. Me and Wendy, we got into Jackson's life. Jackson wasn't even 1 yet. There was times where Erica and Senior, they were living in a trailer, probably no bigger than, no bigger than, I can't even explain it to you. I mean, it was very unlivable conditions. And so we actually me and Wendy together, we've been in Jackson's, Edward's life his whole entire life.
Would you consider yourselves common law married at that time?
Oh, yes, ma'am. Yes, ma'am. We was living under the same roof. Yes, ma'am.
Okay, and you considered her to be your wife and she considered you to be her husband at that time?
Yes, ma'am.
Okay, and you were together 7 years. And when did you how old was Jackson? How old was, I'm sorry, I think his nickname is something else. How old was Junior when he was actually placed with you and Wendy?
You mean after foster care or just through whole entire foster care and everything?
During the pendency of the CPS case, how old was
he was with us. Edward was with us probably since he wasn't even 1 yet. He wasn't even fully poly trained yet.
Okay. And
I'm sorry, I keep getting a clicking noise. I've muted everyone except the attorney and Jeremy Thomas. If anyone's doing anything that's making a clicking noise, I'd appreciate it if you'd stop. And I'm actually going to mute myself. Sometimes noises that the person whose electronic device is on can't hear filter through. So I'm going to mute myself and let you continue.
Okay. Mr. Thomas, when you had Junior, did you have him full-time 24/7?
No, actually, Wendy was the one was there 24/7. I was actually the one I was always working, made sure everything in the house was taken care of as far as financially wise. But as far as like everything, the 24-hour watch, being there, to make sure he's doing his work and all of that stuff, that was Wendy's part.
Okay, and he's 6 right now, is that correct?
Yes, ma'am.
Okay, and it's fair to say that he's lived over 90% of his life with Wendy and you.
Yes, ma'am, that's correct.
Okay, and you had mentioned that Wendy actually helps with his homework. Does she take him to the doctors? Does he?
Yeah, Wendy's always did that. She's always took him to the doctors. Made sure he got enrolled into school. Wendy just put him in football. He's playing football now. So So yeah, and you said 90%. I would say more or less. Junior's been our like 95% of his life.
Okay, so you believe it's in his best interest for Wendy to continue to take care of him and have.
Yes, ma'am, that's correct.
Okay. We are also asking for the court to suspend her visits or reduce her visits. Are you in agreement with that, and why?
Yes, ma'am, because for one, she doesn't pay child support. She still owes almost $5,000 worth of child support. It might be more than that now.
Besides child support, are there any other reasons why her visit should be restricted or suspended?
Well, she doesn't go anyways. She hasn't been there since February, and she hasn't made a visit in March.
Mm-hmm. And Junior?
And before that, she's supposed to do 4 hours a visit, but she only does an hour a visit. She only sees them for a whole hour. And another thing that concerns me, as far as the visitations go, Junior doesn't like to be there. The only reason Junior goes is because so he can see his brother. We ask him questions about, hey, did you see your brother today? No. He said, what did you and Erica do? And he's always like, oh, we didn't do nothing. It was very boring.
Okay, so he's expressed to you that he does not want to go to the visits?
Yes, ma'am.
Okay.
Hey, y'all gonna have to mute me real quick because I just got called into the job.
I think I can get other testimony from his brother, Your Honor. I think he just left. You're on mute, Judge. Your Honor, you're still on mute. Oh, there we go.
Okay, we figured out who the problem was. It was Jeremy Thomas on the clicking noise, whatever that is.
Yeah.
All right, Ms. Thomas has a chance to cross-examine him, but for the time being, you can start with your other witness.
Will do, Your Honor. I would like to call Mr. Franklin Thomas.
All right, go ahead.
Can you unmute yourself, Franklin? Is that okay if I call you Franklin?
Yes, that's fine.
Okay. And Franklin, you're the other brother of Erica, correct?
Yes.
Okay, and you know why we're here today. We're here to ask that for conservatorship for Wendy of Junior. Are you in agreement with that, and why?
Yes, I'm in agreement with it. I have seen both sides of the family on this issue. When it comes to Wendy, she had been essentially the mother, caretaker, nurturer from day one of Edward's life, essentially. She has been really, as far as when it comes to taking care of it, she was the homemaker and Jeremy was the provider. He was bringing them income and everything. But when it came to seeing Edward through everything that he would naturally go through, it was her that was there.
Okay, so have you seen significant differences or changes, improvements to Junior while he's been in the care of Wendy?
I have, as far as from cleanliness to overall behavior patterns to his overall fullness even. There was a period of time where when I visited Edward before Wendy and Jeremy got involved, this was back when Erica and Stanteen were together. There was some questionableness as to whether he would ever get healthy, so to speak. The trailer that they lived in was less than dilapidated, for lack of better terms. And I saw some things there that brought about long before the CPS case. So I kind of knew that all this was going to come to a point.
Okay. So it's fair to say there's been lots of issues that brought the case into the care of the department.
Yes, there is a 180-degree difference between what I saw then under Erica's care to Wendy's care.
Okay. And do you see Wendy and Junior frequently to check in on him?
I haven't seen them very much because of COVID. Apart from seeing them on phone and talking to them, I haven't had a chance to really see them as much as I would like to.
Okay, and when you did see them, can you describe what their relationship looks like, how they interact?
They act as a mother and son does. It's very homely, very happy. He's always wanting to do things, and they're always, catering to his, needs as a child. So I do the same thing with my own daughter. And so when I bring my daughter to them, and they go off and they play and do all the things that wonderful kids do. And so I've never seen anything other than suggest, a happy home.
Would you agree with me that she would be the only mom that he's known throughout his life?
Yeah.
Okay. If you know about the visits
Yes,
that she has at Kid Share? Okay. Do you know do you feel that should continue or if it should be suspended?
I would like to see it suspended.
Right.
Primarily because of several things. There was a time I got to go to one of the visitations with Wendy and Jeremy. And while I was there, Erica actually threatened harm to Wendy while she was present there and over the child. Now at that time, the child was off playing with, I keep calling her Miss Bowman, but I know it's not Miss Bowman. I'm sorry, I'm trying to remember the woman's name, but she was the the caseworker that was helping with the vegetation during that time. And that's one of the things I've seen. I've also seen Erica's erratic behavior that basically led to her online harassment, to slandering both my family and theirs, to the point where I won't even talk to Erica if I can help it.
Okay. So is it fair to say you and Jeremy do not talk to your sister at this time due to the harassment on social media?
I do not partake in social media. I've actually gotten off of it. I've decided I had enough.
Can you tell the court what type of threats she makes or what types of things she posts?
Kidnapping her child. At one point, she threatened to come to Wendy's place of residence. And it got so bad that it prompted Wendy to actually relocate to another part of the city. She talks about something called Featherwood. I don't even know what that is, but somebody said it was connections. So
something called what, sir?
It's something. She said at one point that she had a connection to something called she lived at a place called Fairweather, but she had connections to Featherwood, which is I don't know what that is, but that was her connection to get at Wendy. And that's I've heard personally. I don't know.
Go ahead with your questions, ma'am.
Okay, Franklin, do you believe those threats are credible for her to come and kidnap her son?
Yes.
Why do you believe they're credible threats?
Primarily because I know Edward Stanteen Sr. At the time that the threats were being made, she was still with Edward Stanteen Sr. And Edward Stanteen is for lack of a better term, well connected within a certain community set. And primarily, I don't want to say the word, but the skinhead. And so when they talked about kidnapping, it wouldn't be the first time. She has said in the past also that she does not want Junior to be living with Wendy. And part of it has to do with her race. And not just her, whether she can take care of the child or not. In the past, she had also given, this happened about 3 months after Edward was born. We were called to their trailer, and they wanted to draw up papers for adoption, that myself and my wife would adopt Edward, should CPS ever get involved. So it was something that they kind of knew what might happen. But at the time we turned it down because my wife was also pregnant with my daughter. So it was kind of one of the cases where we got our own hands full, we're about to be new parents. So
So your opinion right now is that it would be in Edward's best interest for him to stay with Wendy, for the visits to be restricted, and also for a stay away order against your sister.
yes.
Okay. I'll pass the witness to for now, Judge.
All right. Now, Ms. Erica Thomas, I need to let you know, this is not a chance for you to testify. You will have a chance to testify on your own behalf shortly. But this is an opportunity for you to ask questions of this witness. So what questions do you have for this witness?
I do have a question. I would like to know why CPS was called on LaKendra and my brother. Like, I don't know the situation.
Objection, Your Honor. I don't believe he has personal knowledge of that.
All right. Mr. Franklin Thomas, you can answer the question. I'll overrule the objection. If you have personal knowledge, you may answer it.
Okay. I didn't know why, for example, why did Erica eventually, okay. Actually, I don't know. I don't think I have any questions at the time.
Ms. Thomas? Do you have any other questions for this witness?
None. I have none.
He's asking Ms. Thomas.
Ms. Thomas, do you have any other questions for this witness?
Oh, I do have another question.
Okay.
I have a question as to why my brother can't take care of Edward anymore.
All right.
Is
And
it
then
because of Deuce?
let me ask you to just put your questions directly to the witness. Okay. You understand what I mean by that?
No, I don't understand.
Okay. Ask him, why can't Jeremy take care of Junior? Don't say, I'd like to know something. Just if you have a question, put it directly to him. Don't phrase it in the third person or anything like that.
I would just like to know why Jeremy can't take care of Edward anymore. That's for him to answer, if he could answer for me.
And that would be only if Franklin knows, Your Honor.
Yes. Mr. Franklin Thomas?
What, say again? What's the question towards me?
Yes.
Oh, okay. Why I couldn't be taking care of Edward now? Is that what the question is?
Not you, Jeremy.
It was Jeremy.
Oh.
If you know.
Oh, what? As far as the only thing I know is that at this current time, Jeremy and Wendy are not together at the moment. So as far as that's all I know.
Muted, Judge.
All right, Mr. Thomas, you went away and you are now muted.
Okay.
The last words I heard from you, I could understand were that's all I know.
Okay, yes. All I know is that Wendy and Jeremy aren't living in the same household right now. That is what the reason they're here for.
Your Honor, can I answer that question?
No, sir. You need to remain muted. We will return to you. All right. Ms. Thomas, what other questions do you have for this witness?
Why CPS?
Remain competent to care for him because of mental illness.
Objection, Your Honor. I believe somebody else is in the room with her.
I don't
giving her
care.
Instructions.
I don't.
Why did CPS deem him unconfident to care for him anymore? Is it because of his mental illness?
Objection, Your Honor. I believe that's improper witness. I believe she's directing the question to Mr. Jeremy Thomas, rather than Mr. Franklin Thomas.
All right, I need to, Erica Thomas, the witness is Franklin Thomas. Do you have other questions for Franklin Thomas?
No, it was, that question was more towards Jeremy, but not Frankie.
Okay, Ms. Aldridge, do you have any follow-up questions for Franklin Thomas?
No, Your Honor, I do not.
All right, Jeremy Thomas, I muted you because we started the next witness just because have short time available. Let me ask you to unmute. All right. Now, Ms. Thomas, you did not get an opportunity to cross-examine Jeremy Thomas a while ago because he had to take off. So what questions do you have for Jeremy Thomas?
I would like to ask why CPS has deemed you unfit to care for Edward Jr.
Objection, Your Honor, that facts are not in evidence in regards to fitness or unfitness of Mr. Jeremy Thomas.
Okay, I'll overrule the objection. I don't know if they have, but so. Mr. Jeremy Thomas?
Yes, sir.
Okay. Do you want to repeat the question, Ms. Erica Thomas?
Yes, I would like to know how CPS deemed you unfit with the mental illness to care,
Your Honor,
care for him.
Your Honor, CPS never gave me a mental illness. And second of all, Your Honor, CPS never found me unfit. I wanted to give my rights over to Wendy for the simple fact that I worked. Wendy can take care of him. I don't have to pay for I don't have to pay for a babysitter, and I don't have to find another mama for for Edward, because he has a mama that's right there in that corner who takes care of him dearly. It shouldn't be no state of fact about a mental illness, because I don't have a mental illness, and I've been evaluated, so I mean, I don't know where she's getting I have a mental illness from.
Your next question, Ms. Thomas?
My next question is, I was notified of some bruises on my son. My brother actually called me, and I wanted to know where those bruises came from.
Objection, relevance.
Well, Your Honor,
I'll ask Ms. Erica Thomas to say which brother.
Jeremy, he actually is the one that reached out to me through phone call. I have evidence of that too.
All right, go ahead, Mr. Jeremy Thomas.
Your Honor, those bruises did not come from Wendy, nor did them bruises come from me, and I can't speak on their behalf because my ex is going through a CPS case right now because of the fact there's an open CPS case on her, not on me, it's on her. So, like I said, those bruises did not come from me, and the CPS is already notified. It is notified of that. And Your Honor, I would like to know on how does she get all that information, because CPS did not give her that information.
Okay, Mr. Thomas, Erica Thomas is the one asking the questions. Your next question, Ms. Thomas?
That's about it. Thank you. Oh, I do have some documentation.
Okay, you'll have an opportunity to testify on your own behalf shortly, ma'am.
Okay.
All right, Ms. Aldrich, what other questions?
And just one follow-up for Jeremy Thomas, Your Honor, if I may.
Go ahead.
Jeremy?
Yeah, I'm here.
The bruises that Miss Erica Thomas is referring to, that has been investigated by CPS, correct?
Correct, yes.
Has it been ruled out by CPS?
I've been ruled out.
Okay. Was Wendy?
Yes, Wendy was ruled out.
Okay, so there's been no fault or any suspicion that either you or Wendy caused those bruises on Junior?
Yes, that's correct.
Okay, I'll pass the witness, Judge.
All right, Ms. Thomas, do you have other questions for this witness?
Yes, I do. Who was supervising them at that time? Because he got the bruises somewhere. Why was he being left unsupervised?
All right, Mr. Thomas?
First of all, Your Honor, he was not unsupervised. Second of all, I worked. I was at work when the incident happened. So, like I said, my ex is the one that's being investigated right now through CPS. I'm not in it. I was not at home. I was at work. She was watching him because she was living under my roof. Her and her daughter and him were living under my roof.
Your Honor, I just wanted to clarify when Jeremy says his ex, it is not Miss Wendy Hastings.
And I can't say, and I can't really speak on that case because it's an open case, and I can't really speak on that. But like I said, once again, for the record, Wendy did not put them bruises on Jackson, nor did I put them bruises on Jackson. But it is an open CPS case, and it's on another party.
Okay. And just to remind Jeremy, just answer the questions, okay?
Yes,
All right,
ma'am.
Mr. Thomas, what other questions do you have for this witness?
So you're telling me that your ex-girlfriend that's not Wendy watched my son
Was in Wendy's care when the incident happened.
when he was in Wendy's care when that happened?
Your Honor, how come there's somebody in that background talking, Your Honor? There's somebody
All right,
back there
Mr.
that's
Thomas,
talking.
Jeremy
that's not on
Thomas,
camera.
Mr. Thomas, you have an attorney. Your attorney can make objections if she wishes to.
I'm not his attorney, Your Honor.
And I have overruled it. So you need to answer the questions that are put to you.
I'm not.
Okay, well, she was my ex. My ex was living with me. She was living under my roof. So who else is going to watch him? What, am I going to pay for a babysitter to watch him when there's somebody's watching him? And no, Wendy was not at the house when it happened. Wendy was not living with me. And for Your Honor, I just want to state this for the record that she's already called my ex and asked my ex questions. How did she get her number? I don't know. And the reason why I know she did is because she told me that Erica called her phone and asked her, stated over the phone, what happened to my son? And she went off and hung up on Erica and her face.
Ms. Thomas, what other questions, if any, do you have for this witness?
That's it.
All right, Ms. Aldridge.
Yes, Your Honor. I just wanted to clarify, Your Honor, I don't represent the men. I represent Miss Lakindra Hastings, and I'm referring to her as Wendy. If I may call her next, Your Honor.
Yes.
Okay. Wendy, can you please state your name for the record?
Hi, yes, my name is Lakindra Hastings, also known as Wendy to many friends and family.
Okay. And Wendy, you are Jeremy's ex-girlfriend, correct?
Yes.
And how long have you been in a relationship with him?
7 years.
Okay. Wendy. Okay. And you also considered yourself his common law wife?
Yes.
Okay. And Erica actually knew of you 7 years ago. Is that fair to say?
Yes.
Okay. Were you at Edward's birth?
Yes.
Okay. And how involved were you up to when CPS got involved?
We will watch Junior every now and again. When Miss Thomas was living in a shelter, we would go and get him and watch him. And there's other times we have to go and pick him up and watch him for them.
Would you say that would be on a weekly basis or a daily basis?
No, not a weekly or daily. It's been like maybe a couple of months in between.
Okay. And when did what year was that when the CPS case started?
2016.
2016. Okay. And at that time, did she voluntarily place Edward with you and Jeremy?
Yes.
Okay. So it was not the department placing him. It was, she actually signed a placement form. Is that correct?
That is correct.
Okay. And when did you and Jeremy separate?
2 years ago.
2 years ago. Where was Edward?
With me.
So
he was living with me.
Okay. Since that final order, what amount of time has Edward not been in your care?
From the final order, maybe 2 months.
2 months. Was that just last fall when he was with his ex? Okay. And he actually reached out to you to see if you can take care of Edward.
Yes.
Okay. And what is your relationship like with Edward?
Great. Wonderful.
Okay. You love him?
Oh, absolutely. I love him.
What do you do for him?
Well, I provide for him. We do a lot of things together. So
Jeremy
I
mentioned
can-
go ahead.
go ahead, I'm sorry.
Jeremy mentioned that he was in sports,
Yes, he is. He's in football.
in football. How's he liking it?
Oh, he loves it. He loves it.
All
He
right.
loves being out there with the big kids practicing. So
Good. And is he in school or pre-K right now?
he's in first grade and he's excelling first grade.
Okay. And do you go to the parent-teacher conferences? Do you take him to school?
Yes, due to COVID, we do Zoom for the parent and teacher conference. I just had one last month. And I do take him and pick him up from school.
Okay, so the teachers and the staff at the school know who his person is, his guardian, his.
Oh, absolutely, they do.
So if there was anything wrong with him or if they had any questions about him, you would be the point person.
They will call me, yes.
Okay. And you also take him to doctor's visits?
I do, I do. He's very healthy, so yes. Dentist as well.
Okay, and you believe that it's in his best interest for you to be appointed his legal guardian or his legal conservator?
Yes.
Okay, and just state if you can state to the court basically why you believe you should have legal guardianship, or I apologize, legal conservatorship.
Conservatorship, yes. I've been on this journey since 2016. Edward came to live with us April 28, 2016. And I've been in his life ever since. He is all that I know. I'm all that he knows. I have a very stern foundation at home, and he knows what a home is. Family, has a big, huge family. So we do a lot of family gatherings, especially before COVID hit. And he's just my world and I am his. I mean, we vibe with each other, you know, so he's my baby, so yeah.
And that family includes both Franklin and Jeremy, correct?
Oh, absolutely, absolutely, absolutely.
And let's talk about Erica's visits. They're at KidShare, and you agree with everybody that's testified that she's missed the 18 months and the month of February. What other times has she missed visits with him?
There was a time, I would like to say June of it was 2000. I remember it was before COVID hit, so, but I took him to his visit, and there was a no call, no show, but we do have to wait because they allow you to wait 15, 20 minutes. So, and they came back and told me that she wasn't there.
Okay, and you actually follow up with KidShare before each weekend to confirm?
I do.
Okay.
I do. We follow up with each other, either call, email. So yes.
Okay. And whenever you've had to miss a visit, you've always had a note or some sort of valid.
Absolutely, absolutely. And or for instance, I did have surgery and they knew ahead of time. And it was an incident that in April I knew I was going to be hospitalized. And so I asked if she can have a visit way before a date. And they contacted Erica, and Erica made a fuss about it because she didn't want her. So I asked her to give her date back. And I don't know, they said that they would, but then I guess the spot got filled up. So she was put on a waiting. But anytime that I do, because it's mainly me, I'm the one that does the visits, they talk to me. KidShare talks to me, I talk to them. So anything regarding Junior, I am the one that talks to everyone. So, so yes, we have missed visits. Absolutely, we did, due to me having surgery, I've been hospitalized twice. Junior's been sick. In fact, the doctor would request him not to be around others because it was contagious. So yes,
Okay, and those visits had been made up, or you've offered to make those up?
We made up some, but it's offered. It's not required.
I see. Okay. And right now you're kind of also at the mercy of KidShare because they also have policies in regards to COVID, correct?
Yes, they do. Yes, they do.
And you're also aware of the calls made in regards to violations of these orders on yours
Yes.
or Jeremy's part. Can you
Yes.
elaborate on that as to what's happening with Erica and her allegations?
Well, I mean, if we miss, here's the thing. Erica loves to post on social media, no matter what it is. Okay. I had to have a sit down with KidShare because of things that she had posted. And I've asked KidShare, please, I'm going to have this surgery, please just don't inform her of the reason why. And they agreed to it because they even saw some of the things that she was posting. And so, yeah. Far as I just lost train of thought. I'm sorry. What was the question?
That's okay. Let's just move to those social posts that you're talking about. Now, you're aware that she's on numerous CPS, anti-CPS
Yes.
social
Yes.
groups and pages and whatnot.
Yes.
Are those concerning to you?
Absolutely. Absolutely.
Okay.
And it's really more towards me, in Germany.
Why are you asking this court to continue, I guess, that stay away order?
Because Ms. Thomas has made threats to kidnap Junior.
Okay.
Several occasions, even made a threat to, what if she takes him from KidShare? What are the police going to do?
Okay, and she's actually posted the location of KidShare on her social media?
December 30th, she had a visitation and she went on Facebook Live.
Okay.
And
she
posted.
Okay, and she's also posted his immunization shots?
Yes.
Her own medical diagnoses?
Yes.
She's posted the last judge who
was on the case?
Presided over her CPS case. So,
yes.
And that's concerning to you?
Absolutely. She's not only did that, she has posted where he goes to the doctor, his address.
And as a result of that, did you have to change doctors?
I did.
Did you have to change your residence due to her actions on social media and other?
I did.
Okay.
Yes.
So
yes.
When was that when you actually had to move?
The first time was in 2017. I moved from one side of San Antonio to the other.
Okay. As a result of what action that she did?
Because with all these postings in these groups with 5,000 people who got their kids taken away for their fault, not their fault, I don't know. But calling me a kidnapper, saying I have stolen her child, it gives other people thinking, if they don't know your whole story and you're just pointing out to one person, she kidnapped my child because she can't have kids of her own. She's no mother. She needs to go and adopt other kids and play house with those kids. And you got all these people saying all kind of things about me. And just like I seen the fact that she said that she was going to come to my house and bring people and then call the police and all this stuff. I have to put Edward first.
Right.
All times.
So you moved, and you moved again after that?
I did. I actually moved again. I moved to Hayes County, and Edward moved with me to Hayes County.
And why did you move this time?
Well, this time it's a new scenery. I know she Googled my address, but at that time, it's not fearful.
Okay. Do you feel she knows where you are right now, or she knows where you live?
She does.
How do you know that?
February 24th at 7:00 p.m., me and Junior sitting in the living room, and I get a knock at the door, and police knock very hard. And it startled Junior. He was like, Mommy, is anybody coming? And I said, no, so I go to the door, I look through the people and I see anything. So I'm like, who is it? And they didn't say anything at first. I was like, who is it? And he said, San Marcos PD. So I opened the door. The officer said, you know why I'm here? I said, San Antonio? He said, yes. And I said, Erica? He said, yes. And I told him, I stopped him before he said anything else to me. I said, let me get the information I got from Child Protective Services and from Jeremy showing that Junior's supposed to be here. So he's looking through old court orders. He's looking, trying to get a hold of the investigator. And he says, well, I'm under the impression that Junior's not supposed to be here. Erica stated that she did not know where he was at. And he's supposed to be with Jeremy. So, I had to explain to the officer what's going on, situation. And he was like, okay, so we're talking and I let him know about some of the things that were said. And then I said, how did you know where I live? He said, I would not have found you. He said, Erica giving me the address.
Okay, and at no point in time did you post your address anywhere or nobody else would have shared?
Absolutely not. Absolutely not.
Do you know the effect on Edward? Has he exhibited any fear or anxiety over what's going on with his mom?
Yes. Even with that officer coming, he asked, was he getting ready to be taken away? And it kind of hurts my soul a little bit because he's been through so much already. And I assured him no. And I asked the officer, I said, would you like to, because he said he was there for a welfare check. I said, would you like to speak to him alone? He says, oh no, I don't need to. I can see he's perfectly fine. And then Junior said, yes, I am perfectly fine. And everybody laughed, but
Okay.
That's just his little.
And Edward's actually in play therapy right now, correct? In regards to this whole situation?
We put him in play therapy in 2019 because he was not coping with visitations. He would cry before he goes, he would throw fits. I would have to calm him down. And I know this may be bad, but I used to have to tell him, hey, everything is okay. I will be here, because he would ask me, are you going to be here when I get out? Are you going to be? Yes, we'll go to Build-A-Bear, wherever you want to go after visitation, whatever, But he was just not coping with it. It was hard for him. He was going in there saying things from what his sheriff's telling me. And so, yeah.
You said he was going in there saying
things to Miss Thomas, like he doesn't want to be there. He doesn't like her. I mean, he would tell us that, but he expressing himself in there. And I would I talk to him. And, I explained to him who Erica is, because he hadn't seen her in a while before, 2019. That was her first visit, was in January 2019. And so it was hard on him. It really was. And even till this day, it's still hard for him.
But you don't discourage these visits?
No, absolutely not.
And you don't badmouth his mom?
No.
Okay. And that's partly the reason that you want the visits reduced from 3 per month.
Well, yes, because she was granted 4 hours in 2017. We went to Kids Share in August 2017 to sign up for the visits. Ms. Thomas didn't make her first visit till January 2019. And in the beginning of January, she did do 2 hours. She has, but ever since after that, it's an hour.
So she doesn't exercise the 4 hours that she's given?
No.
And you heard Jeremy's testimony that he complains about not having much to do during that time, that 1 hour.
Yeah, but when she brings her other child, it brings him little joy in the visitations, because he does love seeing his younger brother. But I try to encourage him to interact with Miss Thomas too. So I guess there are times when they do interact. And, you know, his answers are really short. It's always reflects back on to his younger brother.
And today you're asking the judge for a stay away order. And is it fair to say that if you can't get one, you're gonna have to move again?
I may have to, yes.
Okay, I will pass the witness for now, Judge.
And again, Ms. Thomas, this is an opportunity for you to ask questions of this witness, but not to testify on your own behalf. You'll have a chance to testify on your own behalf shortly. Go ahead, ma'am.
I have a question for LaQuindra. Do I have to pay for my kids' here visits?
Yes, you do. And it was court order when we all went to court.
Okay. I have another question, Your Honor.
Go ahead.
Do you pay the other part of the visitation as well?
No, because when we all went to court, Ms. Thomas, you agreed to pay for your visits. So we are not authorized to pay for your visits. This is something you've been knowing since 2017 in July.
Okay, thank you.
And
Anything else for this witness, Ms. Aldridge?
yes, Your Honor, I just wanted to admit witness affidavits pursuant to the emergency orders. I don't know if you want me to screen share that or just request that they be admitted into evidence. They're marked as petitioners exhibits 3 and 3A.
And are they attached to the petition?
They have been filed, Your Honor. I filed them this morning and I believe they were accepted.
Okay.
Your Honor, I have a question.
All right, and let me just ask, I don't have a copy of those. Does Ms. Thomas have a copy of those?
Judge, I'm sorry. I did accept those. I need to bring them into the courtroom. I can do that right now.
Okay. Does Ms. Thomas have a copy of them?
I just recently got her email address this morning during our conference, Your Honor, and I did not get the affidavits from my own client, except I think I got them yesterday, all of them yesterday.
Okay, well, why don't you go ahead and forward a copy of.
Yes, Your Honor.
Ms. Thomas, what sort of electronic device are you on?
I'm on a laptop.
Okay.
I think I can email her, Your Honor.
Well, that or you could just post them in chat.
Oh, yes.
If it's
Your Honor, I do have a question.
All right, right now what's in front of me is motion to admit the affidavits. Let me let Ms. Aldridge get copies of these affidavits to you so that you can see if you have objections, and then you'll have a chance to testify.
I'm in chat, Your Honor. I know there's a function where I can download it, but
If you go to,
I see three little dots. It says save chat or merge to meeting window. I know when I'm in my own account, I can upload to it.
okay, what sort of thing are you on?
I just put in the Zoom ID.
Okay, but I mean, are you on a laptop, a tablet, a cell phone?
Oh, I'm on the computer, Your Honor, just the desktop.
Okay, if you go to chat and Erica Thomas, next to the 3 little dots, there ought to be something that says file.
Ah, thank you, Judge. There's one, and there's 2. They have both been sent, Your Honor?
Thomas, you should receive those and you should be able to download them and then open them and look at them on that computer there.
And I just had one other question for my client, if I may, Your Honor, while she looks at that.
Go ahead.
Wendy, at one point in time, did you have to send a cease and desist letter to Miss Erica Thomas?
Yes, ma'am.
Why did you need that? And this was before you had counsel, correct?
Yes, yes.
Okay. Why did you feel like you needed to do that?
Because Ms. Thomas implicated me on a current CPS case as the abuser. What's the current CPS case that's going on now, excuse me. Not only that, she's just been slandering my name, my character as a person. And I just felt like enough was enough. I've reached out to so many people that involved with Miss Thomas to help her, to talk to her, to encourage her to stop.
Okay.
But
And
this time she implicated me in this current CPS case, and I have nothing, absolutely nothing to do with.
okay. And you had previously mentioned some social media pages. Does that include Justice for Edward Jr., Fighting
Yes.
CPS, Dad versus CPS?
Yes.
Has she ever referred to Edward as her property?
Yes. Instead of son, she's called him her property. I need to turn over her property.
Okay. And are you aware of her posting a request for babysitters for her children on social media?
Absolutely. Even when Junior's case during CPS, yes. Prior judges and CPS have spoken to her about that.
And do you believe these are appropriate, or, you know, are these, do you believe they're appropriate, or?
They're very inappropriate.
As a parent?
As a parent, yes.
Ms. Aldridge, I need to ask you to move along because we need Thomas's. All right, so before we get to the affidavits, Ms. Thomas, do you have any other questions for this witness right now?
Your Honor, I do have a question for LaKendra.
Go ahead.
LaKendra, I remember going to a visit and my son Edward brought it to my attention that I had to pay for these visits. Who do you know who might have told him that response? Because I know it wasn't me.
Okay, so as you know, as everybody know, that Edward Jr. is very smart for a 6-year-old. At the time when I lived in San Antonio, our rooms are kind of adjacent to each other. So I sends him to his room when I'm having a conversation with CASA workers, CPS workers, because at that time, even though the case closed in 2017, we still had to deal with CPS till they closed the case. So when she came over, you know, she goes over all the guidelines and things. So he may have heard, you know, our conversation.
Okay. And then, Your Honor, I do have another question for her.
All right, Ms. Thomas, just ask your questions directly. You don't have to preface them with any request to me.
Okay. And LaKendra, do you know that if I was to go over to your house, do you know there is such thing as parental kidnapping charges? That's just a question because I'm aware of that.
Parental kidnapping charges? No.
I am aware of that.
Okay.
So I haven't done it for a reason.
Okay. Thank you. Well, I answered no, Your Honor.
Any other questions for this witness?
Now I do have another question. My brother did say that he has another ex-girlfriend, right, besides you, from that I was aware about, right, LaKendra?
Yes.
Okay. Where was Edward at the time of this bruise? Was he in your care or the other ex-girlfriend, or the girlfriend's care?
He was not in my care. He was in Jeremy and at the ex-girlfriend's care.
Do you know this ex-girlfriend or do you not?
I do not know her.
Are you aware, as Edward's mother, that I did ask my brother to press criminal charges on whoever did it?
Yes, and we really can't speak on that, so I don't know if Jeremy, you know, continued to press charge. Erica, I don't know. I don't know. They cannot discuss the case with me, so I don't know.
Okay, because another question is, as a mother, aren't we supposed to be, if our children were to get hurt by somebody and we know that person, and like, say if our son came up to you and say, hey, for example, I'm gonna use my friend.
speculation.
Overrule the
I'm
objection.
I'm trying to make a point here.
Ma'am, I
Your Honor.
overrule the objection. Go ahead with your question.
As a mother, if our child was to come up to you and say, hey, this person hit me, what is your job as a mother that we're supposed to do? Because I know.
Protect the child. You
Exactly.
protect the child.
And you do what by that? Press criminal charges. That is why I asked my brother to do so, because I care about Edward. And y'all make it a big deal like I don't. I love my baby. I miss my baby.
I never said that you don't love him, but your action speaks other word. And again, as far as the issue what's going on with Jeremy and the ex-girlfriend, I cannot speak of it because I do not know of it, but I can tell you that I'm here, I've been here, and I put Junior first, and I will protect him from whoever and whenever. I always put him.
Do you have any other questions for this witness, ma'am?
So I do have another question. My next question is, during the time that I had Edward, did he have any bruises or anything on him when you saw him?
Yes. Yes.
Do you have proof of that?
No, but he was in when we pick him up, you know, so, but no, I didn't take pictures, and it wasn't like a bruise, like, I mean, he probably was crawling on the floor, got little scrapes. He didn't really specify.
Okay, my next question is, you said you got my son in April of 2016, it was, right?
Yes.
How old was he? How many months was he before then?
He was 1.5 years.
Didn't you say that you had him since he was 1?
No, no one asked me.
You told me earlier that you had my son since he was 1. So 1
Year
would
and
be
a half.
12.
Okay, 1.5 years. April, he came to live with us April 28, 2016. He was born August 6, 2014. So actually make him 18 months. But I don't ever, when someone asks me about a child, I don't ever say, well, they're 5 weeks, 6 weeks, 7 weeks, 8 weeks. The turn 1, you're 1, you're halfway to 2, you're 1.5. How old is he? 2? I'm sorry. I never go by.
Okay, I have another question for you.
Okay.
Oh, let me think, I forgot about it. I had it stuck in my head at one point. Were you at my visitations when I was dealing with CPS?
Not inside.
Are you aware that when my son would see me, that he would cry?
That was during the time in foster care. We didn't get him yet, so.
Okay, my next question is, do you have any other children in your home?
No.
Okay, my next question, can you, you know what, Your Honor, I won't answer that question. I have a question for another one, LaKendra. If Edward was to come to you regarding his brother, okay, as woman to woman, if he came up to you and said, oh, he said, I don't like how you, I can never see my brother again, what would your response be?
If your son comes to me and asks me that he can never see his brother again?
Edward, we're talking about Edward. We're talking about Edward.
Oh, I thought you were talking about your other son. Well, honestly, Erica, don't worry about that because Edward is just not that type. He's such a jolly of a kid. He would never. And if he wants to see his other brother, I will do whatever I can to make that happen like I've done before. But I don't ever see Edward saying that.
My next question, how would you be able to do that when I have a child, his baby brother is in my custody?
How? Because your child's father has met up with us on several occasions with Alexander. So
Now, speaking of that,
We're not here for that, but okay.
Your Honor, I think that's all the questions I have at this moment for her.
All right, Ms. Aldridge?
No further
the
questions.
rest? Okay. Are there any objections to the admission of the affidavits? All right, Ms. Thomas, are there objections to the admissions of the affidavits?
Your Honor, I could not open those documentations on my computer. If somebody can email them to me, I could look at them.
I can do
Okay, so I'll set that aside for right now. What witnesses do you have, Ms. Thomas?
At this time, I don't have any witnesses. I was not prepared for this trial.
I mean, are you going to testify on your own behalf?
I do have some witnesses, but they are currently not here today.
But my question right now is, are you going to testify yourself?
Yes.
All right, so go ahead.
I'm here today because I have two children. One is with me, one is not. I would like to thank my brother and Jeremy, my brother Jeremy and LaKendra, for taking Edward in instead of him being in foster care. I want to let y'all know that the reason why I did at that time is because of the fact that me and my brother, we grew up in foster care, and we knew how the foster care system works. So I want to thank y'all for taking him in at that given moment. I also wanted to come on today and said that during the whole COVID situation, I was under quarantine with me and Alex as well. He is currently going to school virtually as well. He is doing very well. He is healthy, he is happy, he has all his shots. He's up to date on his medical stuff. He is one happy little boy. He has a little friend that is a girl. It's really cute.
Judge, at this time, I'd like to object to, I know with pro se's, we give him a little latitude, but we're going into the younger brother at this time, and I think we need to focus on the issues that we're asking the court.
I'll allow the testimony that's been going on, but I'll ask Ms. Thomas to bring it back towards Edward.
Okay, I will bring it towards Edward. So I was okay with when KidShare told me about the whole, she didn't want Edward being at KidShare doing dear COVID. I was like, fine, I'll agree.
You froze up there for a moment.
I was trying to.
All right, I don't know if the other people were seeing the same thing. You froze up, and then your voice and face were not tracking. I'm going to ask you to start over about when.
Okay, during
the KidShare.
During the COVID situation, I felt like she was stripping my rights away when it comes to my visitation with Edward. I've never been tested positive for COVID. I feel like she's been violating my rights with that. I was trying to get on the same page with them because of the fact that they currently have custody. It has not been easy during this whole time that they've had him. I will admit that. I'm his mother. I'm always trying to encourage Edward to have a relationship with his sibling. I've had Edward's siblings since the moment he was born during that CPS case that occurred. And I just want my baby back. Like, I've worked so hard for this, and Your Honor, I'm really asking for a chance. I have stable housing now. I'm not talking to my oldest son's father anymore. I'm trying to better.
Okay,
my
and
life.
Ms. Thomas, what I need to tell you is there's a process to do that, and the process is you need to file a motion to modify to get changes made. This is just on temporary orders on the petition filed by Ms. Hastings. So if you want changes made to that, was it 2017 or 2019 order?
2017, Your Honor.
2017 order, then you're going to have to file a petition to have those changes made. So go ahead, ma'am. I just want you to understand that this isn't about that. Even if you convince me that would be in the child's best interest, I don't have the authority to make any rulings on that because all I have is the motion for temporary orders from Ms. Hastings.
I just don't agree with her having temporary custody. Or even sole custody. I'm willing to put Edward in a rehabilitation with family therapy with me and him to talk about what happened with him. I know he might be angry with me. And I understand that, like, I get that. I grew up in foster care myself, and I've had some issues with the whole thing as well. So that's why I'm willing to do that step for him, because I feel like that's going to be the most important thing. As far as I don't want to like strip Edward away completely. Like I want my family back. And I yes, years ago I might have left them down, and I'm so sorry. I'm trying to change every single day. It just hasn't been easy.
Right, ma'am. What else do you want me to know?
Like I said, I have stable housing for me and my youngest. We've been here since they closed out the case with Edward. I don't plan on moving anytime soon. Me and Alex are happy. We're healthy. We are safe. He has a loving home. We do go to church as well, virtually. Right now, I'm currently having to do it virtually. I do help with babysitting. So he has other friends that he can play with while I babysit, because I at least know where my son is at all times. I'm not sitting here trying to ask for babysitters. If I do ask for babysitters, I have an account with the Texas Department of Public Safety to run background checks on people now. I created that on my own because I wanted to, my goal was I didn't want to lose another child to this, to CPS. So my goal was like, you know what, the whole situation with Edward was a learning experience for me. And I had to, my main goal for Alex was to put him first. And that's what I've done. And I just prefer to have my kids with me. Like,
And what else?
I prefer to also have my family. I don't mind being a single mom, raising 2 boys with the help of family. I really do. Even if we have to do family therapy, all of us, to repair this relationship. Our family goes past beyond my childhood from 3 years old, Your Honor. And I just want my family back. I don't want this bickering and fighting. And the reason why I haven't done anything, like, yes, I will admit that I did post stuff like that on Facebook, but I'm not somebody that's gonna go and take her baby like that, because that is criminal charges. I'm not asking for criminal charges on me. I'm asking to be a mom.
Thank you, ma'am. Ms. Aldridge, what questions do you have?
Just a few
Mr.
questions.
Thomas?
Your Honor. Erica, now, we previously spoke, you denied having any contact with Lakendra, and you also don't want any contact with her, correct?
I really don't, but if we can try to repair this relationship in family therapy, because yes, it'd be great to have another mom for Edward, but not like strip him from me. I feel like if we can do family therapy and she be the next mother figure, because I didn't have my mom growing up. Jeremy didn't have his mom growing up. Frankie didn't have his mom growing up. So in a way, she is a blessing to us. She is like being another mom. And I appreciate her help. I really do. It's just, I don't want my rights stripped from me. Like, I'm trying to better myself.
Okay, but are you grateful? It sounds like you're grateful that Lakendra stepped up and helped you raise your son. Are you grateful and blessed that she's been involved in his life?
Yes, I just.
Okay.
I have to admit, I've been hurt and angry about this, but I'm in therapy. I've remained in therapy since this whole CPS case. I'm on my meds currently right now. I'm trying to continue to better my life for my kids.
My question would be, why did you miss the 18 months that were so critical at that age? Why did you miss 18 months of visits with Edward if it was so important for you to bond with him, to get to know him, to be part of his life?
Because they were restricted. If my rights are not restricted, I could see him more.
So instead of seeing him 3 times a month for 4 hours each time, you preferred not to see him at all. Is that what I'm hearing?
No, I'm asking to unrestrict them.
And I'm asking you why. And I'm asking you why you missed those 18 months.
Because they were restricted. CPS restricted them.
Okay. And then the reasons that you have not been exercising all 4 hours of the visits that you were given, why do you just stay for 1 hour as opposed to the 4 hours?
I've been trying, and then they want to sit here and say that it's only March 9th. I was planning to come and visit him. I was actually, after today's court hearing, I was planning to call KidShare and make some time for him to visit my son. So it's not like I'm not seeing him. I am doing the best that I can as a mother knows how to do.
And KidShare actually has gone to virtual meetings or virtual visits with your child, but yet you still can't make those. Is that correct?
I keep contact with them. I have virtual visits. I have had done virtual visits. There was this, like, I started working, and so my visits are supposed to be on Saturdays, and then sometimes with Kendra we're trying to change it during the week, and then it kind of I know she has a busy schedule and I sit here and have a busy schedule, so it's kind of, like I said, it's kind of hard just having them just on a Saturday. Or it's hard.
You understand the impact on a child when you miss those visits, whether they're virtual or in person. Do you understand?
I understand that, but like I said, it's CPS. If the judge could grant me, even if they're unsupervised visits.
Okay.
Or something like that.
All right. Was there just a huge scream in the background somewhere? All right. I need to ask you, Ms. Thomas, to repeat your last answer because we had some huge interference in the noise.
I basically said CPS restricted my rights to make it harder to me to see my son. I try to make every effort I can to see him. If I can't see him, I miss him. There's not a day that I go out with not thinking of him. And I look at my son that I do have, and I'm like, you know what? This is a blessing for one child to be with me, but I sit here and miss Edward too.
But Erica, do you understand why it's a little confusing that you're telling us that unless you were given full access, you would rather not have any visits with your child for 18 months?
That's not what I'm saying. That's not what I'm saying. I'm saying you please, I'm asking y'all to unsupervise my visits. There's no reason why my visits should be supervised. I have a baby in my custody and he is 4 now.
I'm going to pass the witness, Your Honor.
All right. Anything else, Ms. Thomas?
Like I said, I've had my mistakes in the past. I'm learning to grow from them, Your Honor. I really am. I just want my babies. I want my family back. I don't want to deal with Child Protective Service anymore. Every time they've come back, people may have made false accusations, but they kept closing them out. That's why we're here today, Your Honor. And Your Honor, there is no CPS worker in this courtroom for a reason.
All right, brief argument.
Yes, Your Honor. If I may.
Go ahead.
Your Honor, we are here on the motion for temporary orders. There's 3 things that we're asking for: conservatorship, restriction or suspension of her rights, and as well as a no contact or stay away, which I believe she is also in agreement with. There are no pleadings on file by Miss Erica Thomas. So for her to be requesting anything at this point, I don't believe, the court would be authorized to grant her anything because she has no pleadings on file, Your Honor. We have evidence of the child being with Wendy and Jeremy at the time for the first. He was with them when he was 1.5 years up till last October. And for just briefly for 2 months, he was not with Wendy. So he's been with her the majority of his life. That's all he knows is Wendy. His mother had these rights and she just testified, Your Honor, that, well, I didn't visit him for 18 months because CPS restricted me. So instead of going to see him 3 times a month, Your Honor, for 4 hours, she decided that it would be best if she not see him at all. And now he has issues with his visits with his mother. He's in play therapy, trying to figure out, what's going on with his mother. And this is all with Wendy caring about him, about his well-being, about what's in his best interest. She observed him. She noticed that he had issues with it. She listened to his issues, put him in play therapy. She takes him to school. She is in his life on a daily basis. You've heard her testify. He calls her mommy. She calls her mommy, or he calls her mommy. Jeremy's testified that, he has to go back to Wendy, essentially. Wendy's all he knows. This is from the sole managing conservator, the person that the department trusted to take care of Edward, to do what's best for Edward. And at this point in his lifetime, he believes that what's in Edward's best interest is to stay with Wendy. And that's why we're requesting that she have temporary sole managing conservatorship of Edward, Your Honor. In regards to the visits, she doesn't even exercise it. She doesn't exercise them. She's missed so many. And the ones that she has, Your Honor, she stayed for 1 hour. And of course, you've heard.
Erica Thomas.
Sorry, Your Honor.
Your Honor.
Closing arguments, Ms. Thomas.
I have some documents here that I would like to send in to you. Some actual evidence that I have regarding to the case on Edward that I would like to submit to you. Is it possible I can have your email?
All right.
Or
I gotta tell you, it's improper to contact the judge directly for either side. Okay, this is just temporary orders. This is not a final order that says what's going to happen. The other thing I need to let you know is, as I said before, Ms. Thomas, the only thing the judge can do is rule on the motions they have in front of them. If you want to change what was ruled on in 2017, you can't just verbally ask for that to happen. You're going to have to file a motion to modify in your own right.
Okay,
So what I will do today is that I'm going to appoint temporarily LaKendra Hastings as a managing conservator, and she's going to be a joint managing conservator with Jeremy Thomas. I will construe Jeremy Thomas appearing today and testifying as a witness and supporting this as an appearance by him, because I think he's a mandatory party as the managing conservator of this child.
He signed a waiver, Your Honor.
Okay. A waiver of citation or?
Your Honor.
Waiver of service, Your Honor.
Mr. Thomas, I'm the attorney. A waiver of what?
A waiver of service, Your Honor, so he's been served.
Okay, well, I didn't know that, but he's still the managing conservator until something is changed. But I will appoint Jeremy and Thomas and LaKendra Hastings as, I will appoint LaKendra Hastings and Jeremy Thomas as joint managing conservators temporarily. I will let LaKendra Hastings establish the residence of the child, and I will not change anything else having to do with Erica Thomas's visitation with the child. And I will take her right now at her word that she understands that this needs to be settled through the courts and not by self-help or going out and taking the law into her own hands. I'm going to encourage you again, ma'am, to get a representation so that you can come in and file a motion to modify, and that can be heard and this can be taken care of in the future. And is everyone in agreement that the child has been in Hayes County for at least 6 months?
Yes, Your Honor.
I don't.
All right. Now, Ms. Thomas, how long do you think that Edward has been there?
I don't think long at all, because of the fact that I got documentation for that slander from a San Antonio address. I think she's using 2 addresses.
Hold on, Wendy.
Currently.
Okay, so I don't even know how much time has passed. I don't know if it's too late to file an affidavit countering the motion
Your Honor.
for venue. All right, Ms. Hastings, you have an attorney. You need to, your attorney will speak for you.
Miss Erica Thomas.
I'm not going, I'm sorry.
I'm sorry, Judge, go ahead.
So since we don't have an agreement that the case should be transferred to Hayes County, I'm not going to sign an order today transferring it to Hayes County. But and I also don't have in front of me a motion to transfer it, saying that there's been, or just enter an order stating that there has been no contravening affidavit filed. And again, I'm not making a finding that the time for that has passed. I don't know. I haven't looked at the dates to see if it has or not.
I believe that controverting affidavit is due next Monday. And I also believe Miss Erica Thomas also does not live in Wilson County. None of the parties live in Wilson County, Your Honor.
Okay. Well, and I don't know if there needs to be a motion to have it transferred somewhere else. So Ms. Aldridge, how long will it take you to work up temporary orders?
I was hoping that you would sign it before the mandatory transfer, but you're saying right now you're not going to roll on the motion to transfer?
It's not agreed, and you're telling me the answer time is not passed, so no.
So we'll wait till Monday, and if she objects to it moving to Hayes County, it will have to stay in Wilson County?
No, then we'll have to determine where it goes.
Okay, so I'm out next week, Your Honor, but I could probably get it done. I'm going to try to get it done this week by Friday for your signature. If not, may I get it done the week following spring break, which would be the week of the 22nd?
It's fine with me, as long as everybody's in clear that Miss Erica Thomas's rights have not been changed. I'm also going to ask you, so let me ask who's on. And Norma, what date do I have? Do I for Wilson County the week after spring break?
You have March 29th, Your Honor.
Okay, Ms. Aldridge.
March 29th. Would we have to appear in court, or would that be when I would need to submit the order, Your Honor?
Okay. I'll set it for entry on March the 29th. And what I will tell Ms. Aldridge and Ms. Thomas is the only thing that would be heard that day is if there's a disagreement about whether or not the orders that Ms. Aldridge has drawn up implement what I have just ordered, which is that Lakendra Hastings and Jeremy Thomas are appointed joint managing conservators. Lakendra Hastings can designate the residence and all those related rights of the child. Erica Thomas's rights at this point are not affected. So as long as y'all are in agreement that the order Ms. Aldridge prepares states that no one needs to be here. If you have an objection to it, Ms. Thomas, then you may appear. But again, you would not be saying that you agree with it. You would only be objecting, stating that you don't believe that Ms. Aldridge's order reflects what I've said.
Your Honor, I have a question to you.
Yes, ma'am.
So are you asking for like a counter petition?
I'm just telling you that all the things you want to hear about, yes, ma'am, you're going to have to file a counter petition if you want those heard. Now, it sounds to me like this child has not resided in Wilson County for quite a while. And when that happens and they're gone for more than 6 months, it sounds like the case should be transferred somewhere. And
Bear County.
okay, well, that is not agreed. So we'll see if there's any dispute that I need to settle at a later date, but I will set this for entry on the 29th of March.
Is there a stay away, Your Honor, or no contact order between the parties?
I have not ordering that, but I will remind Ms. Thomas what she had testified to, that she understands that she's going to do nothing but severely injure her case if she's having improper or harassing, contract with Ms. Hastings. So let's keep it through kid share and through the courts.
That's what I've been doing, Your Honor, and I will continue to do so.
All right, so I will see y'all on 3/29,
What time, Your Honor? 9?
9 a.m.
Okay, thank you, Judge. And I don't need her signature on the order. I just need to send it to her and have her review it. And if there's an objection, then she'll need to let the court know. Is that the way you?
She'll need to appear, yes. And you can file written objections, ma'am, if you get access to the e-file system or do it by hand, but yes.
Okay, sounds good. I'll send it to her then. Okay, may we be dismissed, Judge?
Yes.
Okay, thank you so much.
Okay. All right. You need to tell the people on the extradition case that we're going to come back at, we'll call it 25 after. I'm sorry, but I need to put out a couple of brush fires and give Ms. Cavazos a break. She's only had one break before we start that. So we will be back at 25 after, and I will see you then.
So I guess we're done. Yes.
Norma, it's Paula.
Yes, ma'am.
What date did Judge reset this Thomas case or Stanteen case to that we just heard?
March 29th.
Okay, thank you.
Yes, ma'am.
Okay, I'm back. I'm asking the jail to start the video.
Okay, sir, we're gonna go grab him right now.
Thank you.
Where's
Okay, I'm calling habeas corpus 21-00002. In re Douglas Edward Lockbaum. Are both sides ready?
Hey, Judge.
All right, Ms. Lockbaum, you're. Okay, are you ready to proceed, sir?
I am. Thank you, Judge.
Okay, was that a yes?
Yes.
Okay, had the state rested last week?
Judge, if we had not done so, we do so now.
May I help you?
Go ahead, Mr. Lockbaum.
So, Judge, thank you so much. What writ of habeas corpus are we working off of?
The app.
Hey, are you doing transport tomorrow? What do we have? Matthew Walls. Do you know who's sticking? I don't know who. Raymond, do you have a copy, Raymond? Is it a big transport? Take him back to Walls.
All right, what says this? Oh, wait, no, here it is. No, it's the motion to withdraw as counsel.
I didn't see it. When you pulled up, there was no part with it.
All right, so.
Judge, my understanding is we're operating under the one filed February 24th by Ms. Starlin.
Okay, all right, and that's the first document, and that's the second. That's the second document. All right. The application for writ of habeas corpus challenging legality of arrest under said governor's warrant filed February the 24th by your attorneys.
My Honor, I never had an attorney. from the beginning, I've been administering my own affairs. And it was only until the proceedings of this court where I was able to kindly thank the court for their offer of attorney, but let them know that I'm not a decedent or indigent or not capable of administering my own affairs. Kathy Starling was never granted my authority or requested by me to represent me or speak on my behalf. Now, we should be addressing my handwritten writ of habeas corpus that was submitted on December 16th and December 17th, served and submitted to the courts during even Mark Ledette's own testimony at the February 8th hearing, 2021. Mark on record states he received one of my handwritten writs of habeas corpus. He received that on December 30th, 2020. He also stated during that hearing that he was not aware of.
Give me a moment, sir.
Yep. Man, I apologize. I'm at the front desk presiding over this matter, and I have multiple employees of the court that are on phones and other people walking by, so it's a bit hard to hear you. I'm hoping you can hear me all right. It's definitely not any court that I've been a part of.
All right, Mr. Lockbaum. Well, we're doing all sorts of things differently with COVID.
I hear you.
I can tell you, sir, is any writ of habeas corpus you may have filed prior to the time there was a governor's warrant for your extradition was mooted by that governor's warrant for extradition, meaning that before that you were being held awaiting the governor's warrant for extradition. After the governor's warrant, when the extradition arrived, then you're being held on the governor's warrant. So the only writ that's been filed by anyone challenging the governor's warrant is the one that was filed on February the 24th.
Why then did Mark Ledette on January 27th in an email request a motion for an extension?
All right. Mr. Lockbaum, I'm not going to speculate on the state's council's reasons for doing things, but what I will tell you is the reason your attorney filed a new application for writ of habeas corpus on February the 24th of this year is that the filing of the governor's warrant or the receipt of the governor's warrant by the court set all the deadlines over and started over. And whatever you were being held on before that date, you were no longer being held on. Now you're being held on the governor's warrant. So do you wish to present any evidence on the legality of the governor's warrant or whether you are the individual named in the governor's warrant?
Kathy Starling never had authority to submit a habeas corpus, a writ of habeas corpus on my behalf. I never appointed her or requested her or even saw any instrument that she submitted to the court. So I'm confused as far as how we can even move forward and how the prosecutor has any standing in this matter.
Okay.
So
let me put it this way, Mr. Lockbaum.
Granting her
Call
authority.
your first witness.
I'm sorry?
Call your first witness.
So we're moving forward with a writ of habeas corpus that Kathy Starling, who was not my attorney, submitted to the court, and that's what we're proceeding with?
All right. Sir, we're moving forward on the writ of habeas corpus that we started a week ago and you've announced already on. So do you have a witness? Do you have a motion to admit any exhibits?
Well, I'm challenging the standing of the prosecutor and the writ of habeas corpus that I never submitted, that Kathy Starling submitted that had no authority to do so.
Okay, I will take that as a no. So both sides and ask you, do you have anything else on the merits of your writ of habeas corpus attacking the governor's warrant?
My honor, it's not my writ of habeas corpus. I submitted a writ of habeas corpus that Mark Ledette, in his own wording and record, stated that he received on December 30th. That's a writ of right. It is a violation of the Constitution.
Right.
And these acts,
Blackman, that's not what we're hearing. So I'll take that as you have no evidence to bring forward? Since you've called no witnesses and offered no exhibits, there being no case for the state to rebut, I'll ask for arguments from the state.
Judge, simply our argument would be that we've met all our requirements under 5113 of the Uniform Criminal Extradition Act. We've shown that, in fact, Mr. Lockbaum is the person. Through both our exhibits with the fingerprints, they match the same person as in Tennessee. There's a picture of Mr. Lockbaum associated with both those documents that were admitted as evidence. We show that he is wanted out of Tennessee. The governor's warrant at State Exhibit 1 we presented shows not only the capias and the warrants for the outstanding cases he has there. We have shown under Section 6 that he has committed acts through both the affidavit of the prosecuting district attorney of Tennessee, but also through the police reports that he committed acts while in Texas or another state, which caused a crime to be committed in Tennessee. And having met all these requirements, Judge, we'd ask that extradition be granted and we'd be allowed to make him available to the state of Tennessee.
Mr. Lockbaum, your arguments?
My Honor, I object. What excuse do these prosecutors have for misaddressing and/or misimpersonating me as a foreign person, alien with respect to my country, house, and home? I'm a living flesh and blood man. I'm not a person. Mark Ledet is completely inaccurate in what he is sharing. And I would imagine on record stating this information, even his own witness. Last week, on the March 2nd hearing, Todd McCrohan, in his own testimony on March 2nd, 2021, answers my question very plainly on the record, under penalty of perjury, and states and confirms that I am a living flesh and blood man, that I am not an artificial person, that I'm not a corporation, that I'm not a legal fiction, that I'm not a person. So how then is the prosecutor moving forward with a claim that he has clearly identified me as a person when his own witness stated on record that I was not, that I was a living flesh and blood man? That's his witness, not mine.
This is a time for argument, not a time for questions unless they're rhetorical questions. So I'm going to take that as a rhetorical question that you've made as part of your argument. Please continue.
I have clearly stated to the court, to the executive administration, to everybody, that I'm a living flesh and blood man. I am the executor of the estate. I'm here in good standing, and I am the executor over the estate that you are charging. The estate is in full faith and credit, my honor, as I am the executor. And I'm demanding that this case be dismissed. I've been mislabeled, misapprehended by the prosecutors in Tennessee and the prosecutors here in Texas, knowingly moving forward with these false instruments. And I'm asking for the court to see and recognize me as the living flesh and blood man, as an American state national, not a capital U period, capital S period citizen. I'm owed the Constitution.
You're a what, sir?
I am owed the Constitution of the United States, or the Constitution of the United States of America, both. And I'd like to remind the court, it is a capital crime to misidentify and unlawfully convert law-abiding Americans standing on their own soil with nothing that separates me from my creator, in unlawfully converting me into a legal fiction, a corporation, to try to contract or contact with me. I am fighting on behalf of my sons, who told me that they were physically abused and sexually abused by a district attorney in Tennessee. And when I went to the sheriffs, This same process happened to me in Tennessee. I went to the Texas Rangers, the San Antonio FBI, Madison County Sheriff's Office. I went to the local law enforcement in San Antonio, Bexar County. I went everywhere, to the DOJ. I never fled justice. I was the one seeking justice. I am not the criminal here. I'm the victim of crime. And I'm asking for the mercy of the court and my honor to allow me to continue to fight for my sons and their well-being. As a free man, I will handle the situation in Tennessee. But please give me my rights as a father, as a husband, as a son. I'm not a corporation. I see what is going on here. I know what's going on. I've been the victim of it. And I may not be able to articulate it as strongly as Mark or anybody else that's a district attorney or assistant district attorney, but I know what's going on. And instruments of orders of protection, false warrants, corruption in the Tennessee law enforcement offices. I moved to exonerate this court and anything doing with Texas, and I want to handle things in Tennessee and get my sons back. It's been 20 months. I never did anything. I asked the court, what would you do? And it's obvious I can't fight this in here or in Tennessee. My sons told me they were afraid of being kissed like they were married, having hair in their mouth, being woken up and fondled, squeezed so tight they couldn't breathe. And I hear people in here get 10 years for strangulation. My wife's life has been threatened. My life has been threatened. If you look at my history, I'm not a criminal. I've never been in trouble with the law. I don't know why this is happening. All I want to do is get my sons out of a bad situation. And because a district attorney in Madison County resigned after I asked for an investigation, they brought the whole house onto me. There is corruption. It's true. And I need help. And I've gone everywhere. Nobody will do a thing. On November 11th of 2019, when the state of Tennessee is claiming that I was in Tennessee and I called or did something, and the charge that are alleged against me for 2 governor's warrants is that I texted and said, please have my sons call me and you will go to prison. I never threatened anybody. I'm not charged with threatening anybody or going to somebody's residence and trying to harm them. I don't have a history of that. I'm nonviolent. I'm fighting for my sons. But on November 11, 2019, Lieutenant Jesse Valdez of the Texas Rangers and Kevin Callahan of the Texas Rangers spent almost 2 hours with me and my wife. A corporation can't have a wife and a corporation can't have sons. In our home, and we told them this information. If needed, I can give you the recording and the video of them sitting in my office, in my home. And I told them what was happening, told them about the threats to our lives. And nobody's done a thing. And now the same people who are covering up the child abuse, crimes against children, are potentially going to be allowed to come extradite me and put me in this situation where you can't fight for anything in this situation. I will handle things. I want to see my sons. It's been 20 months. There's not a day that's gone by that I haven't fought for them. And nobody will help. Judge Wilson, I'm asking you for help. I'm asking Mark for help. I'm asking Cindy. These people here. I'm a grown man crying here because nobody will help it, and I'm angry. And it's wrong, and nobody will help. My 4 sons. I will handle it. I need your help, Judge. Please let me walk out of here and handle this. Put a monitor on me. Do whatever you need to do. I'm not going to hurt anybody. I just want to get my sons. But I can't fight for them in here. I can't fight for them in there. And my life has been threatened. Judge, I'm not lying to you. I swear under oath. Their lives have been threatened. My life has been threatened. I have recordings, I have video, I have audio, I have everything. Allow me to present charges here of child abuse. Let me bring the evidence to you or somebody. We're running a fiscal audit of the books in Tennessee. The hours or days away that will show the fiduciary fraud that's happening. I have all the instruments, and I may not be able to articulate it. I'm pro se, but I see it. I just need help. I've spent over $60,000 with attorneys that have told me one thing: they're going to get disbarred. They have no standing. People are going to get arrested, and then the moment we get into court, something changes. Now all of a sudden, I'm this thing, this entity, and I have no rights, and they don't help my sons. Now, maybe because I'm going off script here, I'm hurting myself. I got no other way of discussing this. I think that you know or understand what I'm saying, but I'm just not equipped with the sharp tools to share that. This is not my landscape right now. I believe this will be for the rest of my career to help others that are going through this and to do good. But I'm not there yet. I need help. I just want to go and help my sons. That's it. I'm not going to go. Whatever they've claimed to stop since November, apparently, Hugh Harvey in Tennessee shared that I wasn't violent. They tried to keep me without bond in San Antonio. Judge Carruthers didn't want a part of it, issued bond, allowed me an ankle monitor to handle the affairs in Tennessee. And I've made mistakes. I regret those mistakes. But what was I supposed to do? Let a piece of paper when people have threatened me and my wife and my children and cover up child abuse and not advocate peacefully? I don't know any other parent who wouldn't have done other things. I tell my story to people and they say, I can't believe that you're not in prison for harming somebody. I have calls with District Attorney Jody Pickens, Danny Goodman, Jerry Estes. I have calls with everybody. I've never been unprofessional, rude, because I had to advocate for my children. TJ King was a history with Ralph Hazelhurst and the Hazelhurst. Has goaded me many times and threatened me on audio, and so the other sheriffs. I've never once responded in a way that would have me in dishonor. I'm acting in honor. I'm seeking the truth, honor, in good faith. I've been drained financially. My career has been ruined. I used to make $190,000 a year as an executive leader for 18 years. I can't get a job because of what's on my background in Madison County. I make pizzas at Pizza Hut and Papa John's. I've been extorted for $11,000 of back due child support that I paid $6,500 a month for. One thing after another, the courts have been used to ruin my life and steal my kids and threaten my life and my children's life. And I'm asking you, please, Honor, allow me to walk out of here and fight this.
Mr. Lockbaum, you're talking about a lot of things that it sounds like you need to fight, but they need to be fought in Tennessee. They need to be litigated in Tennessee.
I have to get it on record. Nobody will take it.
My charge is to enforce the law or to administer the law in court and not to go out and right the wrongs of the entire world, sir. Even if you were saying that this was happening in Travis County, I'd say that you would have to litigate that and get that investigated and taken care of in Travis County, Texas. I have absolutely no jurisdiction to do anything in Tennessee. That's going to have to be handled by state court or federal court in Tennessee.
I tried. My Honor, I thought that if I told responsible people that they had a duty to stop a wrong from continuing or prevent a wrong from happening, I'm reading everything that I can get my hands on to try to figure out this landscape. And it changes with moving goalposts everywhere that I go, and nobody will help me. I've spent everything. What would you do if it was your son? Or Cindy, if it was your son, grandchildren? Because I don't have family that's involved in the courts or friends, or I haven't worked here, that I can't get help. That's what it is in Tennessee. That's not right.
I don't know what it's like in Tennessee. I can tell you that I'm not sure where you're going with some of your arguments, sir. You said you're entitled to deserve the Constitution, or you're entitled to it, and you're right. Article 4, Section 2 says that a person charged in any state who can be found in another state on demand of the executive from which they fled shall be delivered up to be removed to the state having jurisdiction of the crime. The state of Tennessee has filed the proper paperwork saying that it has jurisdiction over you in a crime. I don't know if that's true, but whether they got it right or wrong is not something that the court in Texas can litigate. You're going to have to litigate that in Tennessee. Overrule the writ of application for writ of habeas corpus to challenge the governor's warrant. I'll ask the state's attorney, Mr. Leday, to prepare whatever I need to sign reflecting that and allowing the clock to start ticking for the Tennessee officials to come to Floresville. And how long do they have to make that happen?
I'm not sure offhand, Judge.
I'm not either. All right, is there anything else we need to do today?
Not from state, Judge.
All right, then this matter is concluded. I'm going to leave the meeting. I'll ask Ms. Riley to terminate the Zoom trial.
Thank you.